All right, everyone, please be seated. Ladies and gentlemen of the jury, I've been informed by the deputy that you've reached a verdict. Is that correct?
Yes, ma'am.
And is that verdict unanimous?
I believe so, yes.
All right, thank you. All right, defendant could stand. Count one, we the jury find the defendant Marcos Contreras guilty of aggravated robbery as charged in count one of the indictment. Count two, we the jury find the defendant Marcos Contreras guilty of aggravated robbery as charged in count two of the indictment. And count three, we the jury find the defendant Marcos Contreras not guilty of count three. All right, please be seated. Would anyone wish to have the jury polled?
Judge, just based on the hesitation, I would ask that, yes.
All right, thank you. All right, we will start with count number one. Ladies and gentlemen, we're going to ask you individually whether or not in count one, this is your verdict. We'll start at this end. On the first row, is this your verdict?
Yes, ma'am.
Is this your verdict?
Yes.
Is this your verdict? Is this your verdict?
Yes.
Is this, that's okay. Is this your verdict? Is this your verdict?
Yes.
Is this your verdict?
Yes.
We'll start on the back row here. Is this your verdict? Is this your verdict?
Yes.
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 We'll now move on to count two of the indictment. And we'll go in the same order before. Is this your verdict?
Yes, ma'am.
Is this your verdict?
Yes.
Is this your verdict? Is this your verdict?
Yes.
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 Is this your verdict? Is this your verdict?
Yes.
Is this your verdict?
Yes.
Is this your verdict? Is this your verdict? Defense, are you asking that be polled as to count three?
No,
All right, ladies and gentlemen of the jury, we're now going to move to the second phase, which is the punishment phase. State, do you have an opening statement?
No, Judge, we put it.
Defense opening statements?
we do not.
All right, to state any evidence to present.
We do, Judge. We would offer state's exhibits.
Would you prefer with us, Brenda, to start over or
You're
continue?
on 16.
16, 17, and 18.
Any objections to state 16, 17, and 18?
No, Your Honor, I reviewed them with my client. We are stipulating that it's the same person in these 10 documents.
All right, then states exhibits 16, 17, and 18 are admitted into evidence. State, any other evidence to present?
No, Your Honor.
State, do you rest?
Yes, state rest.
Defense?
Judge may have just a few moments with my client.
Yes.
You rest.
All right, state, do you close?
Yes, Your Honor.
Defense, do you close?
Close.
All right, ladies and gentlemen, the jury, just give us a few moments so that we can give you the charge for the next phase. All right, so you're still under oath for your duties. So just give us a moment, okay? All right, everyone, please rise for the jurors. All right, state.
And Judge, at this point, the state would make a motion to reopen evidence for the brief purpose we discussed outside the presence of the
All
jury.
right, any objections?
I do object.
That'll be overruled. State.
Repeat offender allegation, enhancement allegation. And it is further presented in and to said court that before the commission of the offense alleged above, on the 14th day of June, AD 2010, in cause number 2009 CR 11697 in Bexar County, Texas, the defendant was convicted of the felony of unlawful carry of a weapon on a licensed premise.
How do you plead to that? True or not true?
True.
Right, you may be seated. State, any further evidence?
No, Your Honor.
State, do you rest
Yes, Your Honor.
and do you close?
Yes.
Defense, rest and close.
Yes, Your Honor. I just want to make clear the only evidence we did admit 16 through 18. I just can't
Yes.
remember. Marcus.
Yes.
Thank you.
All right, ladies and gentlemen of the jury, I'm going to read to you what is entitled the charge of the court on punishment. Members of the jury, the defendant, Marco Contreras, has been found guilty of aggravated robbery with a deadly weapon in count 1 and count 2, as alleged in the indictment. The repeat offender enhancement allegation paragraph of the indictment alleges that before the commission of the offenses in count 1 and count 2, as alleged above, on the 14th day of June 2010 and cause number 2009 CR 11697 in Bexar County, Texas, the defendant was convicted of the felony on unlawful carry of a weapon licensed premises. To the repeat offender enhancement allegation paragraph of the indictment, the defendant has pleaded true. You will find the defendant, Marcus Contreras, has previously been finally convicted of felony offense as alleged in the indictment. You will so state in your verdict that you find true the allegations in the repeat offender enhancement allegation paragraph of the indictment and assess the punishment of the defendant in each count at confinement in the Texas Department of Criminal Justice Institutional Division for life or for any term of not more than 99 years or less than 15 years. In addition to imprisonment, an individual may be punished by a fine not to exceed $10,000. And if you choose to assess a fine in addition to imprisonment, you will assess such fine and so state in your verdict. If there is any evidence before you that the defendant may have previously committed offenses or acts of misconduct other than that for which you have convicted him, you are instructed that this evidence, if any, was admitted to assist you, if it does, in determining what sentence is appropriate in the case at hand. However, as to the evidence of the prior offenses or acts of misconduct, if any, for which the defendant was not convicted, you may consider that evidence in assessing punishment only if you first believe beyond a reasonable doubt that the defendant committed this other offense or offenses or act or acts of misconduct, if any. In the event you have a reasonable doubt as to whether any other such offense or act of misconduct was committed, or as to whether the defendant was involved in such other offense or act of misconduct, then you will wholly disregard the evidence, if any, which may relate to any such matter. You are instructed that the defendant may testify in his own behalf if he chooses to do so. But if he elects not to do so, that fact cannot be taken by you as a circumstance against him or prejudice him in any way. The defendant has elected not to testify in this punishment phase of the trial, and you are instructed that you cannot and must not refer or allude to that fact throughout your deliberations or take it into consideration for any purpose whatsoever. In your deliberations, you may consider evidence introduced during the guilt phase of the trial, as well as any evidence introduced at the punishment phase of the trial. Under the instructions herein given, it will not be proper for you in determining the penalty to be assessed to fix the same by lot, chance, any system of averages, or any other method than by a full, fair, and free exercise of the opinion of the individual jurors under the evidence admitted before you. The length of time for which a defendant is in prison may be reduced by the award of parole. Under the law applicable in this case, the defendant will not become eligible for parole until the actual time served equals 1/2 of the sentence imposed, or 30 years, whichever is less. Eligibility for parole does not guarantee that parole will be granted. It cannot accurately be predicted how the parole law might be applied to this defendant because the application of that law will depend on decisions made by parole authorities. You may consider the existence of the parole law. You are not to consider the manner in which the parole law may be applied to this particular defendant. A suitable form is attached hereto for your verdict if you should care to use the same. However, such form is not intended to influence you in any way in arriving at your verdict. In any event, your verdict must be unanimous in writing and signed by your presiding juror. Respectfully submitted, Stephanie Boyd, Judge of the 187th District Court. Verdict forms are attached. State.
Thank you, Judge. We started off this trial, we told you that the range of punishment is the first degree was 5 to 99. But we told you that because there are some circumstances where it could be enhanced to 15 to 99. So that's what we're doing for the prior conviction. I'm going to go over some of the evidence that was admitted, show you the prior conviction that he has. We're going to talk about the facts of the real case, and then I'm going to give you what I think the number should be, my recommendation. So first off, we have State's Exhibit 16. This is a prior felony conviction for Marco Contreras. As you can see, the offense date of February 26, 2004. The offense is for possession of a controlled substance, PG1, 1 to 4 grams. In this situation, Mr. Contreras was given a chance, terms and conditions of community supervision. He was given a chance at probation. He didn't comply with probation. He ended up being revoked and was sentenced to 6 months. That was in 2004. That's Exhibit 17. Date of offense, 6/23/2009. The offense is possession of marijuana, 4 ounces to 5 pounds. In this situation, he was sentenced to 4 years. 566 Exhibit 18, which is the one that you read or heard in the charge. Same offense date. Unlawfully carrying a weapon in licensed premises, and he was sentenced to 4 years. Over the past 20 years, Mr. Contreras hasn't done. In fact, he's stepping his game up. He went from possessing drugs to possessing weapons, now using weapons against innocent individuals. The way that you know that he's enhancing this behavior and becoming worse and more detriment is that he committed this crime in broad daylight. And when confronted, he didn't do what, I guess, a reasonable person would do. He upped it even more, and he put out a knife. The range is 15 to 99. We believe that based on his past criminal history, his behavior on this particular occasion that you all found him guilty of, that an appropriate punishment would be somewhere no less than 25. I don't think this is the worst aggravator. I mean, this was an aggravated assault like that. Fortunately, no one was injured. But there's a concern with Mr. Contreras being out of society, and so we believe that no less than 25 would be appropriate.
Defense.
Good afternoon. Juries all the time come back with guilty verdicts, and I always tell them we respect it. Y'all are the ones that are doing your job. We appreciate it. We accept it. Of course, Mr. Contreras doesn't want to be here, but he asked you to make a decision. You made it. You have another decision to make. And just because 2/3 of the decision went against him doesn't mean that this one should, in as far as his sentence. If you think about your own common sense, when you think about why someone should go to prison, let's talk about the different factors. First of all, what type of things have they done in the past, right? Are those things violent? What's their background like? Did they hurt anyone in this particular incident? There is a prior, but the prior is already built into this punishment level. In other words, because Mr. Contreras went to prison before, that's already factored into his punishment. In other words, he could have had a prior of murder, and his punishment range would be 15 to life. he could have had a drug possession and his punishment range would be 15 to life. What I'd say about prison, and I'd ask you to think about it this way, is there aren't prisons for people that probably got high and had a knife but didn't hurt anyone. The prisons are for murderers and rapists and a whole bunch of bad and nasty people. And so when the state says like 25 years, that I want you to think about where you were 25 years ago. I mean, where I was 25 years ago is, gosh, I was as young as some of my head, but you know what? 25 years is a long time. And you get to consider that he's not even eligible for parole until half that time. So what I'm asking you to do is minimums are there for a reason. I ask you to consider that Mr. Contreras really did not hurt anyone. And I'm not so sure how close he was to hurting someone. None of the people testified they were in fear. It's hard for me to ask for things that I don't think are fair with a straight face, but I do think 15 years is appropriate in this case. No one was hurt before, no one was hurt this time. Man has a drug problem and does stupid things. I'm not saying he doesn't deserve to be punished, get drug treatment in prison and come out, but 15 years from now, for God's sake, the man's gonna have a gray beard and gray hair. He'll be a different person, hopefully a better person. But I think that's enough time to punish him for what he did. I just, respectfully, I just think 25 years is too much. I'd ask you to consider my arguments. So we'd ask for 15 years on count one and 15 years on count two. Thank you all for your time.
All right, any further argument from the state?
No, Your Honor.
All right, thank you. Ladies and gentlemen, the jury, you are now free to go and deliberate on punishment. Everyone, please rise for the jurors. All right, everyone, please be seated. Okay, all right, now we'll fill that out and get it sent today. Okay. I think-
Did you want me to go on? You said Thursday, right?
Yes,
Because you aren't gonna do.
thank you. All right, everyone. Welcome to afternoon docket. We are actually in a jury trial. That's why we are starting the docket at this time. So these are the rules of the court. To everyone, you are in a courtroom, even though you are by Zoom. To all attorneys, if you could, it would make it easier and we could move quicker if you would put in the your name, if you will put the name of your client, add that, and whether or not it's criminal trial division or family violence. I'm going to open up the breakout rooms. When I open up breakout rooms, it will invite everyone to go to the breakout room. Please do not go to the breakout rooms unless I specifically call you by name and assign you to the breakout room. If you have an agreement with the state, no matter how small that agreement is, you'll need to put it in the chat box to Ms. Ferguson. She's logging in now. If your client is on bond, we will need your client's email address. This is the order in which attorneys will appear. To the defendants, your attorney's name will be called. Your name will not be called. If you do not hear your attorney's name, they will be with us shortly. James Seeloff, Jesse Sanchez, John Kuntz, Kelly Pittle, Fernando Ramos, Catherine Valenzuela, Gail Calderola, James Ishimoto, Barry Hitchens, Nathaniel Navy, Orlando Castagnone, Paul Smith, Rusty Geyer, Teresa Conley, Bill Simmons, Miguel Nahara, Jonathan Chavez, Michael Gross, Bertram Wood. Is there any attorney who is on the Zoom screen and I did not call your name?
Michael Goins, Your Honor.
All right, thank you, Mr. Goins. Anyone else?
Melissa Christian, Judge.
All right, anyone else?
Hey,
Hi,
guys.
Judge. Nathan Sleman. I'm not sure. I don't think I heard you call my name.
All right.
And I have an individual who we made special arrangements for him to Zoom in from the Atascosa County Jail. My
Yes,
understanding from
he's on. Just-
okay, that they're limited on time.
Yes, just give me a moment. And who else?
John
Hey,
District, Your Honor, the defendant is Elijah Hamilton.
Just a
Paul
second.
Smith.
Oh, I'm sorry. Just a second. There's been a female who's been trying to answer. Yes.
It's Pauline May Garza.
All right, and I have John Disrude and Mr. Acevedo. I'll have you in the courtroom. Who else? Anyone else on the Zoom?
Judge, I didn't hear you call Neil Kalfish. You may have. If you did, I apologize.
All right, thank you. I have you down.
Thank you.
Anyone else?
Your
All
Honor,
right.
Ron Bonatore here, Judge. I'm here for Jenny Zarka.
Okay, Ronald. Sorry. All right, to everyone else, if you are not an attorney, you need to make sure, one, that you're on mute. Two, your screen is not to go dark, but only for two reasons. One, you're signing paperwork, or two, someone has called you on the phone, in which case you need to immediately decline that phone call. All right, James Seeloff.
Yes, Your Honor. Eric Avalos is my client and it's family violence.
All right, just one moment. Let me rename you. All right, and just so I'm sure everyone is aware, we had a medical emergency with someone on the Zoom screen on Monday. So if you are an attorney, I assume that you know the location of your client. But if you are an attorney and you are somewhere where you are by yourself, it would help us if there were a medical emergency on your end that we knew how to locate you and didn't have to Google you like we had to Google the other person who had a medical emergency. So if you feel comfortable doing it, you can put in the chat box to myself. I'm listed on the screen as Judge Boyd. You can put in the chat box to myself your address where you're located. So if there are issues, we'll be able to get medical personnel to you sooner rather than later. And hopefully no one needs that. All right, James Seeloff, I'm going to send you to breakout room number 3.
Thank you very much, Your Honor.
You're welcome. Jesse Sanchez.
Yes, Judge, I'm here on Ms. Lumpkin. We were set to do a plea in County Court 12, and the case here would be dismissed. They're in trial. They're recalling the case for Monday. So we can do the plea.
All right, and that is on Miss Lumpkin.
Lumpkin, yes. And just in
Miss
case.
Ferguson on Lumpkin.
Lumpkin, yes, Tisha Lumpkin Fortenberry.
Okay. All right, Ms. Ferguson on Lumpkin, if you could set that for, I believe, May 9th, please. You and your client are excused.
Okay, thank you, Judge.
Yes. John Koontz, bye-bye.
Hey, Judge, how are you?
Oh, I'm doing great.
Good. So if I could talk to probation first, because this is an MTR.
All right, is it criminal trial division or family violence?
I don't believe there are any new number ones, and it should be CTD, yes.
All right, probation, if you could meet with Mr. Koontz in breakout room number 4, please.
Judge, can you make me a co-host, please?
Thank you.
Kelly Piddle.
Judge, I'm with James Ishimoto, Miguel Nahara, Orlando Castellon. It's a capital murder.
You are listed as a co-host.
I'm sorry?
Sorry, Mr. Koontz, if you go to breakout room number 4, please. All right. All right, Kelly Piddle, you're pro tem on Montez. Who are the other parties involved?
Miguel, James Ishimoto, and Orlando Castellon.
All right. And are all those parties here?
I think I saw them all, Judge.
I am here,
I'm
Judge.
present, Judge.
All right, what is happening?
Judge, we were back from we went to Miguel's office and reviewed all the discovery to make sure that we had everything that they had, and we believe that is the case now.
It's our thing.
Did I say something wrong?
No, it's that we were having problems on our end.
Okay, no problem.
Okay, so what is happening?
Judge,
Judge, and I believe Kelly explained it pretty well. We were coming back for discovery compliance. We had motion setting before. They have since provided us with CVs on their experts. We did have some issues and some missing discovery. We went to Miguel's office, went through the file. We found part that was missing, and then Miguel went through and verified that there was no additional discovery that state possessed. And so I believe that we have all our discovery at this moment.
All right, Ms. Ferguson, let me find Mr. Montez. All right, so on Mr. Montez, I'm assuming an offer has been tendered, is that correct?
Yes, Judge.
All right, and
Judge, we're losing you again.
sign it. You'll have to do it from here.
I'll do it from there, Judge.
Yes. Somebody goes to the back, sign it.
Yeah, what you need, man?
If nobody's coming on in.
Huh?
Nobody's talking to me. I haven't talked to
Guess what, man?
No, I'm a Yana Smith.
patient.
I mean, cause I think I missed my because it clicked and then it went off and then it went down.
Here, they don't want you clicking right now.
All right, is everyone able to hear me now? Hopefully we're not freezing. So Mr. Montez, are you all requesting a jury trial?
Yes, Judge.
And you have all your discovery?
Yes, Judge.
All right, Ms. Ferguson, I need a jury trial date in the box for Mr. Montez, please.
Are you cool with that?
And is this the only case that you all have with us today?
That is correct, Judge.
Not me, Judge. I actually also have Mr. Abelardo Torres, CTD. So after we're done here, you can put me in a breakout room for CTD.
All right, I'm just waiting for a jury trial date on this.
And Judge, there are two co-defendants on this case who are represented by counsel. After we get that date, would you like us to run that date by those attorneys to make sure they're available and get back to you as soon as possible, or how do you want to do that?
No, this is going to be the jury trial date.
Okay.
Ms. Ferguson, do you have a jury trial date?
Judge, it's been in the chat box.
It's not in the chat box. You sent it to the wrong person.
No, it says Judge Boyd.
There are two Judge Boyds on the screen. All right, we're coming back on July 26th. That's your jury trial date. Mr. Montez, we will see you in court on that date. You'll be brought over dressed for trial. You'll be brought over in whatever clothing you were arrested in. If the clothing is not clothing that you wish to appear before a jury in, let your attorneys know and they will make arrangements for a clothing exchange. Attorneys, if there's an issue with the clothing exchange, let the court know and we'll see what we can do to expedite that.
Please don't get mad at me, but I know I had this issue before. That's I on another case, I told you that's when I'm going to be in New Orleans.
All right, August 26th, that's your jury trial date.
I apologize about that, Judge. I
No
appreciate your
problem.
patience.
You're welcome. All right, Mr. Montez can go back. And to the state and defense, I'll need a discovery acknowledgement signed in 2 weeks, please.
Yes, Judge.
Yes, Judge.
Thank you. You're excused.
And for me, Judge,
Fernando Ramos.
I was
I'm sorry, Miguel, who do you have?
Abelardo Torres, it's a CTD drug case, Judge.
All right, I'll send you to breakout room number 5.
Judge, Judge, I'm sorry to interrupt. August 26th lands on a Friday. I didn't mean to put August 26th. It would have been August 2nd.
All right, have those attorneys come back. Are you available August 2nd, Mr. Nahara?
I should be, Judge. Let me check here. I was putting the other date in. That should not be a problem, Judge.
All right, so it's going to be August 2nd. All right, and then Mr. Nahara, I'm going to send you to breakout room number 5.
Thank you, Judge.
Fernando Ramos.
Yes, ma'am. Now I see there's 2 of you. Double the justice.
I'll send you to number 6.
Thank you, ma'am.
You're welcome. Catherine Valenzuela.
Yes, Your Honor, I'm here for Tony Jimenez, and he has Mr. Leach on the docket, and it was a discovery compliance.
All right, I'll send you to number 7.
Okay.
Gail Calderola.
I'm present, Your Honor, and so is my client, and I just need to confer with the state.
What is your client's name?
I'm sorry, it's Gilberto Sanchez.
Criminal trial division or family violence?
It's criminal trial division.
I'll send you to number 8.
Thank you, Judge.
You're welcome. All right, to the prosecutors who Zoom back in on Montez, it's actually going to be set for jury trial on August 2nd. Barry Hitchens.
Yes, Your Honor. Melissa Christian and I are on Daniel Van Duzer on different cases, though.
Is it criminal trial division or family violence?
Both cases, criminal trial division.
All right, I'll send you and Melissa Christian to breakout room number 9.
Thank you, Your Honor.
You're welcome. Ms. Christian, are you there?
I'm here, Judge. I'll pop over to 9. Thank you very much.
No problem. You have no pen. I can't recognize you.
I know, I'm camouflaged.
Nathaniel Navy, I'll send you to number 10.
Thank you.
You're welcome. Paul Smith.
Hey, morning. I apologize. James or John and I are here on Mr. Hamilton.
Is it criminal trial division or family violence?
I want to say it's criminal trial. We have an aggravated assault with a deadly weapon. I believe it involves a family member, but I don't know that they charged it that way.
All right, let me check. Yes, it's criminal trial division.
Okay.
And who is with you on this?
John District. Yeah.
All right, I'll send you both to number 11.
Okay, thank you.
You're welcome. Rusty Geyer.
Good afternoon, Judge. I conferred yesterday. My client, I believe, is here. He's Zooming from Austin, and we have want a hearing on a motion to suppress. I believe it was going to be set somewhere around 45 days out.
Where's your client?
That would be Joe Guerra, Your Honor.
Joe Guerra. Joe Guerra. All right, we'll wait for him to appear. Teresa Conley, who do you have?
Make sure he has a.
John Carlo Armstrong, family violence.
All right, I'll send you to number 12.
Thank you.
You're welcome. Bill Simmons.
Good afternoon, Your Honor. I have Kevin Debnan. I believe that's a criminal trial division judge.
I'll send you to number 13. Jonathan Chavez.
Yes, Your Honor. I'm here on a Victor Rivas. It's a CTD case.
I'll send you to 14.
Thank you.
Michael Gross.
Afternoon, Judge.
Good afternoon. I'll send you to 15.
Judge, Mr. Montoya picked up a DWI last night. I had the family tell pretrial services right away this morning at 08. So you should have a violation report on him coming up. This is a guy, Your Honor, who was on partial house arrest. And then you authorized him statewide travel for his business. I would respectfully request, Judge, when you see the violation, if you could please leave the bond the way it is and do full house arrest. He is bonding out now at Travis County on the DWI first with a $3,500 bond. And we just wanted you to know about this right away today. I didn't want you getting surprised by it down the road.
Okay, is he on the docket today?
He is, yes, ma'am.
All right. I'll send you to number 15.
Thank you, Judge.
You're welcome. And Michael Gollins, you've been sent to 17. Garza?
Yes, Judge.
All right. I'm going to send you to number 19.
Thank you.
Ronald Benary.
I'm here, Judge. Good
Yes,
afternoon.
who's your client?
It's Robert Chevalier and then Daniel Vasquez. There's two. They're both family violence.
I'm going to send you to 21.
Thank you, Judge.
You're welcome. All right, any attorney who's here who hasn't been assigned, Rolando, I'm assigning you now.
Judge, I don't know if I could just speak with you briefly.
Yes.
We're conferred on this case, Your Honor. She's present with counsel, by the way, Roxana Bernal. We already submitted the PTD paperwork. She was approved, it's been submitted. We're just waiting for it to come through.
Kano? Theoretically, yes.
That was done on 3/23, Judge. So it's been about a month and we haven't heard back yet from PTD.
All right, we'll try to see what the issue is. So just give us a moment. Ms. Ferguson, can you check on the PTD status for Roxana Bernal, please?
Thank you, Judge.
You're welcome. And Alberto Acevedo?
Hello?
Alberto Acevedo.
Here you go.
Judge, can you hear me?
Yes, I can.
Judge, can I get a room with Laura Mendoza?
All right, courtroom, I'm going to send you to breakout room number 1. And is your client in custody or on bond?
She's in custody and I have one other client that's here in person, Judge Marla Garrison.
All right, I'll send Mendoza to breakout room number 1.
Thank you, Judge.
Thank you. All right, Catherine Valenzuela.
Yes, Your Honor, I conferred with Marcus regarding Mr. Leach's discovery issues. It was regarding the meds. The state has them. They're just trying to get them in the right format to give to Mr. Jimenez. But they're working on that, and I understand they've been busy this week. Mr. Jimenez will be back on the 10th, Your Honor.
All right, so it's for you to open up the medical records, correct?
I think that was the issue, and then we were trying to get paper copies, and so the state is finding the method to give them to us.
That's,
All right.
Judge, that's correct. Since it's medical records, there's a password, and the password that it should be isn't working. So Tony asked if we had a paper copy for him, but I told him we only received the digital also. So I'm trying to find out what the correct password is.
All right, and when do you think you'll have that, Mr. Sanders?
Judge, I would think within the next week. I don't think it'll take too long.
All right. Ms. Ferguson, can we put Mr. Leach on May 9th, please? All right, Ms. Norma, you can let them know that Mr. Leach can go back.
Your Honor.
Yes. All right. And we have lost Miss Catherine Valenzuela. All right. Paul Smith, Elijah Hamilton.
Yes, Judge, we're back. We just need a trial date. We have all the discovery.
All right, Ms. Ferguson, can I get a jury trial date in the chat box for Mr. Hamilton, please? Yes. Okay, all right, thank you. Just give me 5 minutes. All right, so Ms. Ferguson, can I have a jury trial date in the chat box on Mr. Hamilton, please?
Yes, ma'am. I was on the phone with pretrial services, Judge. The application is still being reviewed, so needs a 30-day reset.
So what date do you want to put Ms. Bernal on, please?
Give me 1 second.
All right, that June 2nd date, is that for jury trial or for Ms. Bernal?
Ms. Bernal.
All right, Mr. Arguez,
Yes, Your Honor.
your client is coming back on June 2nd for PTD.
Yes, Judge.
All right, you and your client are excused. And then I need a jury trial date for Hamilton.
Thank you, Judge. You have a great day.
Thank you, you too.
Okay.
Judge, can I approach?
Just a moment. All right, your jury trial date, Mr. Hamilton, is going to be June 21st. You'll be brought over dressed from trial if you're still at the Bexar County Jail. If not, you'll need to appear in person dressed for trial. Your trial will start at 9 a.m. Do you understand?
He's indicating his head shaking up and down, Your Honor. I believe he's on mute. May I go in a breakout room with him and may we be excused from there?
No, he'll need to come back to the main room.
Okay.
Mr. Hamilton, you'll be brought over, if you're at the jail, you're going to be brought over in whatever clothing you were arrested in or the clothing that you came with at the jail. So if for any reason that's not the clothing you want to wear, then you'll need to make arrangements with your attorney to have different clothing. Mr. Smith, if there's an issue with the clothing exchange, let the court know and we'll see what we can do.
Certainly, Your Honor, certainly.
I'll send you to breakout room number 2, Mr. Smith.
Thank you, Judge.
All right, Mr. Acevedo.
Your Honor, on Ms. Mendoza, the state and I have come to an agreement and they're going to be withdrawing the MTR. She's already speaking to the CLO in a breakout room.
All right, thank you. You're excused.
And then I'm still working on the other one, Judge, so I'll be here.
All right, and is that Laura Mendoza?
That is Laura Mendoza and she's in custody.
All right, thank you.
Thank you, Judge.
All right, if everyone will give me a brief moment to take a verdict from the jury and I will be right back with you. So everyone just be patient.
We'll try it. If the phone equipment works.
Screen is not on, please. Because I don't want viewers to see the screen.
Judge, also,
Yes.
in this cost number, we do have the discovery acknowledgement.
All right, thank you.
They gave it to me. I misplaced it. Sorry. Seems like Oliver always does. My voice didn't sound good enough to me, so I stopped talking.
What happened to our meeting?
So we have worked on things. We don't know what it is. Again, revise and then we're bringing forth. What works in here is I found those. And I also
When you do a trial.
We're ready.
Usually they do that.
Yes.
All right, to the jury.
All right, please be seated, everyone. All right, ladies and gentlemen, the jury, it's the court's understanding that you've reached a verdict. Is that true?
Yes, ma'am.
All right, if you could hand the verdict form to the deputy, please. All right, as to count one, the jury assessed punishment at 15 years in the prison, and there's to be no fine. As to count two, the jury assesses 15 years in the prison, and there's to be no fine. You may be seated. Does there anyone who wish to poll the jury? State.
No, Your Honor.
Defense.
No, Your Honor.
All right, ladies and gentlemen of the jury, thank you so much for your service. I will meet you in the jury room. Thank you. And
Judge, I have to go and take care of my child. Would you please tell them thank you? I just don't, I would normally talk to
Sure.
them, but I need to go.
most definitely.
I appreciate it. And I'm sorry, you were going to say something to me before I rudely interrupted you.
With regards to, just one second, I'll say. All right. I need to do the trial court certification for your client.
Okay, excellent.
Do we need to pronounce the sentence also?
I'm sorry, I cannot see you without my glasses. It's been one of those days. So if you can come forward.
Oh, sorry. Judge, it's okay. Judge, do we need to pronounce the sentence on him also?
Yes.
Okay.
I didn't know this was live. It is. Oh, it shows. We are live. Huh? We are.
There's like little readers, right?
No, they're big, like, oh, I found them.
Where are they? I don't even
They're
see them.
hiding back here.
I didn't even see them.
I
Oh,
just
there
saw
they
them
are.
flashing.
Okay. I see them.
Thank you so much. I appreciate it. Any attorneys who are ready?
I'm ready, Judge. Oh, wait, hold on. You've got a bunch of hands up.
Hayek has a plea ready.
Your Honor, Teresa Conley, I was
All right,
almost in the
just one moment.
All right, just hold on, Mr. Gracia, please.
All right, everyone. Just give me a moment. I appreciate your patience. And we're going to move as quickly as possible. Mr. Porter, I'm going to assign you to breakout room number 5.
Judge, I apologize. I think I may have put family instead of CTD.
All right, let me change that. There you go. All right, Miguel Nahara on Taurus.
Yes, Judge. I have conferred with my client and the state. They gave me an offer. I know this case is an older case. Sadly, it was attorney who passed away, so I was put on. So this is technically my first setting. I've gotten most of the discovery. I just haven't downloaded all of it. I need just one more pretrial setting, Judge, because I also need to look into a psych issue. I was in contact with my client's family who said he had actually gone into a mental hospital multiple times. So I may need to psych him as well, and I'll get on that ASAP.
All right. So is your client on bond or in custody?
He's in custody, Judge.
All right, I'm trying to find him on the screen.
I didn't tell him to walk away, Judge, but mentally he's a little.
He's still in the breakout room. I understand. All right, Ms. Ferguson on Mr. Torres, can I have a 30-day reset in the chat box, please? All right, I'm just waiting for that as soon as okay, we're gonna come back on June 2nd.
Not on my calendar, Judge.
All right, thank you. You're excused.
Thank you, Your Honor.
And Norma, can you let them know that Mr. Torres can go back? He is 14Q. Abelardo Torres.
Yes, ma'am.
Hi, your case is going to be recalled for June 2nd.
June 2nd.
Yes.
Come back. All right.
Yes. Thank you.
All right. Have a nice day.
You too. All right, Anton Hayek.
Right here, Your Honor.
Yes.
Should have a plea on Joe Thomas, and I have an Emily Casillas MTR, and I haven't been able to talk to anybody on that.
All right, so let me see if I have the paperwork for your other case. Just give me a moment. All right, and who is the other person, Mr. Hayek?
Joe Thomas should be the plea, and Emily Casillas MTR.
All right, have you been given the paperwork on Thomas?
Yes, I have.
And who is the other person?
Emily Casillas. She's an MTR.
Emily Casillas, is that criminal trial division or family violence?
I think it's criminal trial division.
All right, Mr.
Let me
Hayek.
look real quick. Emily Casillas. Emily Casillas is an MTR in possession of controlled substance.
All right, I've sent you to breakout room number 3.
Great,
Rusty
Your Honor.
Geyer, you're welcome.
Thank you.
Your client, Mr. Guerra, is here. What is happening with Mr. Guerra?
We conferred yesterday, Your Honor. We were just, I appeared. I failed to get him the proper link yesterday. So we conferred. We have a motion to suppress, which needs setting.
All right. To the clerks, I need the file on Mr. Guerra. I don't have it, please.
Yes, Judge.
All right, Miss, and you said that this would be dispositive. Is that correct, Mr. Geyer?
That is correct, Your Honor.
All right, Ms. Ferguson, can I have a date for a motion to suppress on Joe Guerra, please? And if we could just set it in the afternoon, maybe Monday afternoon. All right, we're going to come back on May 27th. That will be in person. It'll be at 2 p.m. I'm sorry, what did you say, Ms. Ferguson?
It's June 27th.
All right, June 27th at 2 p.m., Mr. Dyer. And Mr.
Right,
Dyer,
hold
that
on.
would be in person. If you wish to have it by Zoom, let the state know. And of course, your client will have to sign a request and a consent to appear by Zoom as opposed to in person.
No, I prefer in person, Your Honor. So we'll be there.
All right, thank
27th.
you. June 27th at 2 p.m.
2 p.m. Thank you, Judge.
Thank
May we be excused?
Yes. Nathaniel Navy?
Yes, Judge. The state, I believe they need more time to reach out to the complaining witness in this case. I haven't received an offer at this point. I still need to make my way over to the DA's office to review the PAC video. I also filed a motion to amend bond condition, Judge. Michelle Hayden had to, I think she had to run to a meeting, but if I could confer with Mr. Villarreal when he has a moment to see if we can agree on that motion.
Right, just one moment before we do that, let me give you a date. All right, Ms. Ferguson, can I have a 30-day reset on Mr. Herrera? All right, we're going to come back on June 2nd. And at that time, the state will be prepared to give you an offer and you should have all discovery. And with regards to your other matter, I'll send you to breakout room number 2.
Okay, thank you, Judge.
You're welcome. Mr. Hitchings?
Slow to unmute. Melissa Christian and I both representing Daniel Van Duzer, Melissa Christian on an arson pre-indictment. I think that's to be enhanced, and I represent him on a drug case with a repeater enhancement, making it a first degree. I don't think either of us have received offers. Certainly Melissa hasn't on a pre-indictment. And we
What is your
conferred
client's Van Duzer?
Van Duzer, VANDOOZER. Yeah,
All right, well, if you go to the breakout room, the state will give you an offer.
okay.
Actually, Judge, they're sort of like putting my case first, the arson case first, and Mr. Joe Ray Garcia and I have conferred about that. We're in the process of getting additional discovery really for each other. And so we are asking for a reset date.
All right, and I see that the last time we were here, there was, the defense was dropping off of this thumb drive.
I did receive that, Judge. I did get that and they've uploaded it and I picked it back up. But there's some additional issues with respect to the start of this fire and some investigative things that we have to do.
All right, Ms. Ferguson, if I can have a 30-day reset on Van Duzer. At that time, the state is going to make you an offer. And then I'm going to give you a plea deadline date.
Understood.
All right, we're going to be back on June 2nd. And you and your client are excused.
Here, Your Honor.
All right,
I have one more case, Judge.
All right, then if you will change your name to that, and Ms. Christian, if you would stop camouflaging yourself so I can recognize you.
Sorry about that. I
Where
apologize.
the pen? I'm like, I don't recognize her without her pens. Then I'm alone in the world with my pens. I don't have my partner.
I would do it for you on here, but I can't, I don't know how to do it.
Here we go. So the other case I have, Judge, is Juan Hernandez, and he apparently is in the courtroom. It is family violence. I spoke to Mr. Villarreal about that case. Mr. Hernandez has an additional case coming down, and so the state is waiting for that to drop.
And what is it Juan Hernandez?
It is, Judge.
All right, to the courtroom, could you have Mr. Juan Hernandez come forward, please? And state, I'm so sorry, I see you there, but let me take up Juan Hernandez and then Mr. Acevedo, I'll take you next.
Thank you, Judge. Sorry.
So do they give you a idea of when this new case will be here?
Apparently it has just barely made it to their investigations or their intake team. And but they also have to check with Mr. Lunan to see if it has some trafficking features, apparently. So I would assume 30 days, Judge, would be sufficient, but I don't want to speak for the state.
All right, Ms. Ferguson, can I have a a 30-day reset on Mr. Hernandez, please?
Huh? She going? No.
She's your client?
Yeah, she had a couple family members that got murdered.
All right, we're going to come back on June 1st.
June 1st. Judge, could I request that I have it on June 2nd, the same as my other case? Would that be possible?
Yes.
Okay, I appreciate that.
All right, we'll be back on June 1st. I'm sorry, June 2nd.
Okay.
All right, Mr.
I will be
Hernandez,
pinned.
wait until you get a reset form.
All right, may I be excused now, Judge?
Yes, you may be excused.
Thank you very much.
All right, Mr. Acevedo.
Your Honor, my client just stepped out of the courtroom. I'm gonna go get her really quick.
All right, no problem.
Sorry about
Mr.
that.
Stateson, you're always patient as ever.
Of course. Hello, Judge.
Hello, I'm going to send you to breakout room number 4 if you haven't spoken with anyone.
I have not. Yes, please.
All right, Anthony Cantrell.
Yes, Judge, if I could get back with Michael, family violence, I think we have a deal on my case.
All right, thank you. I'm going to send you to breakout room number 6.
Thank you.
And everyone, just give me one moment. All right, Mr. Benari.
Yes, Your Honor.
Yes, who are your clients?
Daniel Vasquez and Robert Chevalier. I was conferring with Michelle Hayden, and then I think I got bumped out while I was in there.
All right, let me send you back. I'm going to send you to number 7.
Okay, thank you, Judge.
You're welcome. All right, Alberto Acevedo.
Your Honor, I'm here on Marla Garrison. She's, you want me to call her up?
Yes.
Ms. Garrison. Judge, we were here, I think, on Monday or Tuesday. on a PSI, and at that time I let you know that there was some things going on in terms of the restitution, that she was trying to come up with the rest of that money, but unfortunately that an assault was committed and a theft was committed, so they stole our belongings. Right now, she's paid half the restitution, or a little bit over half the restitution. I've spoken with Ryan. He said he would defer to the court. We're asking for a week to see if we can just pay the rest of this off. I know this is an old case, Judge, but unfortunately, she also had a couple family members that passed away the last couple of days, so she's going through a lot. So I just asked the court if we can get 1 week so that we can pay the remaining restitution. Part of the agreement was that the state had agreed to a motion for new trial as long as that was completed.
So Ms. Garrison, are you going to have that in a week?
Yes, ma'am.
All right, so here's the thing, what I found in my experience with life, Ms. Garrison. Sometimes people will tell you what they think you want to hear. So if you're not going to be able to have it within a week, let me know that you're not going to be able to have it within a week. Do you understand?
Yes, ma'am. Okay, so this is the thing with this boy. One of my cousins just passed away right now. She was in critical condition, and they just called and said that she passed away. 2 of my other cousins passed away. I'm trying to come up with the money right now. My husband just called and said he might have half of it right now. So as soon as I get it, I'm gonna come right down here and pay it. I just need a few days to get it together.
All right, so what I'm hearing from you is that you're going to have it within a week?
Yes, ma'am.
All right, I'm sorry about the tragedy that has happened to you. All right, Ms. Ferguson, can you recall this in 2 weeks, please? And Mr. Acevedo, the court is not going to give any further resets past this.
Yes,
Thank you, Your Honor.
Thank you so much.
All right. All right, so we're going to come back on May 9th.
Thank you, Your Honor.
And I'm writing in the docketing sheet that this is the last reset for money. You understand?
Yes, ma'am.
If there's nothing else, they'll give you a reset form, Ms. Garrison, and we'll see you on May 9th.
Okay.
Thank you, Judge. May I be excused?
Yes. Is there any other attorney who's ready? Ms. Conley?
Your Honor, excuse me. Sorry. I was conferring with Michelle, and when the jury came out, we got knocked off.
All right, who is your client?
Armstrong.
Oh, and if I could see Mr. Sanders and Mr. Groomer, please.
Yes, Judge.
All right, Ms. Conley, I'm going to send you to breakout room number 9.
Thank you, Your Honor.
Your Honor, this is Arlene. Day.
All right, just give me a moment. All right, just give me 1 second. All right, Ms. Gay, who do you have?
Yes, Your Honor. I have Aaron Strum. I couldn't change it on my phone. I'm actually in the courtroom.
All right, is it
May I
Strong or
see-
Strom?
Strum. And she is present on Zoom. I'd like to see if I can speak to Michael Villarreal.
All right, I'll send you to a breakout room.
Thank you.
All right, you're welcome. And I'm sending you to breakout room number 10.
Judge, Gross,
Just
when
a
you have-
moment. Just a
Yes,
moment.
Absolutely.
Ms. Gay, I'm trying to find you on my screen. So just give me a moment. Oh, no. There's a different screen that I have. But I appreciate the help. Yes, Mr. Gross.
Judge, I'm up here at the State Bar for the Board of Disciplinary Appeals. I was wondering if it'd be possible to get a reset on the case. The state and I are still trying to get the Facebook social media records and the phone records in the case. We don't have those yet for discussion. And so I could get back in the meeting. I was wondering if we could please get a reset, Your Honor.
Where's your client?
This is the gentleman, Your Honor, that picked up the DWI last night. We let pretrial know the first thing this morning. You should have a violation report there. Where I mentioned that he was on partial house arrest. And then last time we were in front of you, he was authorized to travel around the state for business. I'm respectfully requesting, Judge, you leave the bond the way it is and you just put him in full house arrest for now.
All right, Mr. Villarreal, do you, the court is in receipt of the violation report where it's alleged that he has committed the offense of driving while intoxicated. Are you asking for anything else other than having the defendant placed on full house arrest?
Yes, Your Honor, as he's violated a condition of bond, state would move that he be remanded without bond until a further proceeding.
Mr. Gross, your client is going to have to appear before the court. I am going to remand him without bond, and we'll set this hearing for May 9th.
Judge, could we do this, please? He's in Travis County. He's bonding out now on a $3,500 bond for the DWI. If we could leave the bond the way it is and then have the hearing on May 9th, he'll be able to logistically get back to the house on bond and not be able to leave. And then we can appear in front of you on May 9th, Judge.
The court's going to issue a judge's warrant. Remand him without bond, and we'll have the hearing on May 9th. Ms. Ferguson, we'll need to have a bond hearing on Mr. Rudolph Montoya on May 9th, please. And we'll do that at 2 p.m. All right, see you then, Mr. Gross.
Thank you, Judge.
Permission to approach, Your Honor.
Who's speaking?
Attorney Bill Simmons, Your Honor.
Yes, Mr. Simmons.
I've conferred on the Debnam matter. We had the sentencing. He currently has an appeal that's pending, and the offer that was conveyed, I think an abundance of caution would suggest that he needs to discuss that with his appellate attorney prior to taking it. And I don't want to, given that he has another attorney on his appeal, I don't want to interfere with that client-attorney relationship. I can convey that to Mr. Debnam, but there's an offer on the case. I'm not sure. Obviously, I don't know at this time whether or not he would take that, but I do know that at the very least he would need to have some communication with his appellate attorney in his consideration of that offer.
Who's his appellate attorney?
I believe Mr. Hendrickson.
Is that Christian Hendrickson? Mr. Simmons.
I'm trying to look at it now, Judge.
All right, thank you.
I'm sorry, it's Barry Paul Hitchings.
Oh, Barry Hitchens. Barry Hitchens may still be on here. Let me see. Ah, he's left. So in all of the cases, do you have the discovery?
Yes, Your Honor.
And for Mr. Debnap, are we here
Outside
just,
the witness list, Judge. I don't have the witness list.
all right, are we here on, because there's several cases, are we here for 2020 CR 9622, 2019 CR 6494, 2019 CR 6495, and 2019 CR 6485? Is that what we're here for?
Yes, Your Honor. They're all set today.
All right. And so has an offer been tendered in all of the cases?
Today we just got the a new offer that would take care of these cases. But again, I would say based on the offer in the case that would possibly require a plea, I just don't see how that wouldn't impact his, or possibly impact the appellate, the appeal.
All right, Ms. Ferguson, can I have a jury trial date for Mr. Debnap, Mr. Simmons? This will be your client's jury trial date plus a plea deadline date. So between now and this date, you'll have a chance, hopefully, to speak with his appellate attorney.
Yes, sir.
And Ms. Ferguson, if you can place that in the chat box, please.
And I'm not sure how long they're turning those around in terms of the appeals, and I wouldn't ask the court to anticipate, but that's the only reason I would ask the court for as long of a period of time between now and his trial date as possible, because we may, get the ruling. I think that would render it moot. I mean, the issue.
Just give me a moment. I'm just waiting for a date. All
Yes,
right.
Judge.
We're going to come back on July 5th.
Okay, Judge. If I could be placed in, I'm sorry.
I'm sorry, that's going to be your jury trial date, Mr. Debnap, and your plea deadline date. And I'll send you to a breakout room with Mr. Debnap, Mr. Simmons. And if you could have him come back to the main room after you finish speaking with him.
Yes, Judge. The only other thing is that there are, within those cases, there's some separate dates. So they're not all outside, not all within the same nucleus of facts. So my question is that the plea deadline for all of the cases, regardless of the event date?
Yes. And I'll send you to breakout room number 2. And if you want to confer with the state on which case to proceed on first, of course, you're more than welcome to do that.
Yes, Judge.
And if you all have an agreement on what cases you want to proceed on, the court will abide by that.
Yes, Judge.
All right, Mr. Debnap, if you'll go to that breakout room, please. All right, Mr. Navy.
Yes, Judge. If you would just entertain a brief argument on our motion to amend condition of bond.
Yes. All right, State, are you ready to proceed on this motion?
Yes, Your Honor.
All right, the court is calling 2022 CR 0149 4-7 State of Texas versus Michael Isaiah Herrera. Can I have parties announced for the record, please, for the state?
Michael Villarreal for the state.
For the defense?
Nathaniel Navy.
And are you Mr. Herrera?
Yes.
We're proceeding by video due to the pandemic. Any objections from the state?
And from the state, Your Honor.
Any objections from the defense?
No, Your Honor.
The defense has filed a motion asking that the bond conditions be amended. Defense, have you had a chance to review that document?
Yes, Judge.
And state, have you had a chance to review that document?
I have, Your Honor.
State, are you ready to proceed?
Yes, Your Honor.
All right, defense, it's your motion.
Thank you, Judge. Judge, in this case, my client was released on bond on January 15th of this year. He's been on GPS house arrest for work only and to have no contact with the alleged victim in this case. To my knowledge, he's had no violations of his bond conditions to date. So roughly over 3 months and no violations. He's been abiding by it, keeping in touch with pretrial services. He's given his work schedule to pretrial services. He works at the restaurant, Judge. I believe he's a host at that restaurant. And he also has some irregular hours that at various times the restaurant will see if he's available, but usually because he has a set schedule and he wants to work those additional hours, he won't be able to because he'll get short notice of that. He'll have to provide 24-hour notice, which he's unable to do. And so he does miss out on a lot of shifts, Judge. I'm asking if we could downgrade his GPS from partial for work only, as according to his schedule, to GPS tracking, Judge. The complaining witness in this case lives in Caldwell County, and my client already, as a condition of his bond, is not allowed to go outside of Bexar County anyways. So there would be no issues with any contact with the complaining witness in this case, even if it was downgraded to tracking, because I assume as soon as he went anywhere outside of Bexar County, the ankle monitor would go off anyways, and he would be in violation of his GPS. So that would, in my opinion, address any concerns that the court had for the safety of the community. However, the main objective of bond is to make sure that Mr. Herrera does show back up to court. He's made every court date that he's been required to thus far, and the burden of the ankle monitor and has taken a toll on him mentally and physically, missing out on shifts, missing out on family events, missing out just being able to go outside of his own home, Judge. And so I would just ask that you downgrade it to tracking so that he can not only be able to make those additional shifts, but just have more freedom during this pretrial phase. And he would not even be able to leave the county without there being a violation, and the complaining witness lives outside the county anyways, Judge. So there would be really no chance of contact there anyways.
All right, state.
Your Honor, the state's not trying to be punitive in this sense of we believe that he should have the ability to work and provide for himself. We have concerns as regards to the community with just an open tracking as it relates to having unsupervised contact with children under the age of 17, as obviously as alleged in this case, and it's an indecency by a child with a child by contact. And so we're asking that he be allowed to work, which he already is. And I think there's some other ways that we can work around this issue, that he be allowed certain days or just certain places that he can go for work, basically having an open-ended partial GPS that he is allowed at any time either to be at work or at home. But the concern is if we just tracking only, then we can't really say where he's going, who he's hanging out with. Tracking only could mean that he's going to a daycare, and we wouldn't have any notice of that until something potentially could happen. And so based on the safety concerns that we have for our community, based on the nature of the offense and the allegations, we'd ask that you have a more creative solution than tracking only on this case.
All right, so Mr. Navy, it appears that the state's concerns is based upon the nature of the charge, that your client not be around any children. So
Yes.
how do we address that issue?
Well, I know that we discussed this, but we're amenable to, if you wanted to even add a condition of GPS tracking, that he was not to have any unsupervised visit with minors, Judge. Obviously, a restaurant, there's going to be a lot of people in there anyways, but it's a big crowded area, Judge, and just that he have no unsupervised visitation with minors. He has no issue with that, Judge. He'll abide by that, and I think that, you know, we could what if this to death, think of any worst case scenario in any situation, but I don't think that's appropriate, Judge. He's still, at this point, not been proven guilty of anything, and he's made all of his court dates. The complaining witness, as I said, you know, lives out of town, and I think it's reasonable in this situation.
All right, State, how do you feel about the defendant not being allowed to have any unsupervised contact with minors, which, of course, on these cases, the court always orders?
Yes, Your Honor. I mean, there's a difference between ordering it and then ensuring that he doesn't. We obviously have safety concerns based on the nature of the offense. I agree with Mr. Navy that he has not been convicted of this, and so these are allegations. However, the allegations in and of itself, I believe the state has a legitimate concern in ensuring for the safety of the community. So that's kind of where we stand as far as the condition of bond as it relates to GPS.
All right, Mr. Navy, with regards to his working, the court allows him to work because I believe he's on partial for working. Is that correct?
That's correct, Judge.
So the court will allow him to work at any time he wishes to work. He just needs to provide proof of that. Now, if there is anything else, the court can allow him to have a window of time, and that window of time will be for him to spend with his family if he wants to spend with his family. But again, in that window of time, he won't be allowed unsupervised contact. So he will need to pick a date, because I realize that sometimes people have necessities of life that they need to take care of, grocery shopping and so forth. I will give him a window of time to do that once a week. And I will put in there no unsupervised contact with minors. During that window of time, he's allowed to take care of whatever necessities he wants. If there is some issue with him being with family, you know, if they're having a barbecue or whatever may happen, he'll need to come and get permission from the court.
Okay, Judge. So I guess that window of time, is that basically 1 day a week? Are you saying that he would be able to? Okay. And he just has to tell pretrial supervision which day that would be?
Yes.
Okay.
And Judge, I apologize if I made a face on Zoom. It was not based on this hearing. I just messed up paperwork and had to redo it all. So it was frustration with myself, not with the.
Well, thanks for letting me know. I did not see that.
Oh, I didn't want your mother saying anything. It was directed at myself and not the court.
You know, my mom always says that if ever I'm in any danger, she doesn't need to drive or fly because she thinks that she can run and get to me faster. So mind you, that's over 300 miles. So she can win the Olympics and get here rather than driving or flying. So I think she would have been knocking on your door, Michael.
Okay, good to know. Good to know.
So Mr. Herrera, you will be allowed to work. And 1 day out of the week, if there is something for necessities, just let probation know. I'm going to give him a window of time, Mr. Navy. It can be in the morning or the afternoon. We're not going to go into the, as my grandmother would say, we're not going to go in the time frame when the street lights come on.
Fair enough, Judge.
Yes. So what time frame? I'm not asking for a specific date, whether it be, you know, Monday, Tuesday, Wednesday, Thursday, Friday, or Saturday or Sunday, but I want to know what time frame are you asking for him on whatever day he chooses?
Well, I think, and what time frame would the court consider? Is it considering just like, would the court consider just like an 8-hour time frame, or are you just talking about one morning?
Yes, we can do, the only thing is he can leave his house in the morning, but he must be back at home before the street lights come on.
Okay, that's fair
So
enough. Judge.
6 PM is going to be his deadline.
Okay, that works. I would just request then 8 a.m. to 6 p.m. on that date, whatever date that is.
Mr. Villarreal, do you have any objections to 8 a.m. to 6 p.m.?
No, that seems like a fair accommodation.
So you'll be allowed to work whenever, Mr. Herrera. You'll just have to provide proof for pretrial services. And with regards to pretrial services, if for any reason, Mr. Nady, he's called in to work unexpectedly, leave a message with pretrial services. Mr. Navy will tell you, when I receive these pretrial violations, I usually have the attorney and the defendant come in so we can address whatever pretrial issues. And if that's the issue and you bring documentation of that, we won't have a problem. So the defendant is allowed to work upon proof, and the defendant is allowed 1 day per week. From 8 a.m. to 6 p.m. to complete any necessary errands with no unsupervised contact with minors. All right, is there anything else with regards to that from either side?
Nothing further from the state, Your Honor.
No, Judge, that's it. Thank you.
All right, thank you. You and your client are excused.
Thank you, Judge.
Approach Your Honor, Fernando Ramos.
Just one moment.
You have a nice
Yes.
day, Judge.
Yes, Mr. Ramos.
Judge, we've negotiated with Michael. He's not the primary. Michelle Hayden is. There's still some discovery. I got notice this morning about 1 a.m. about some transcripts. Michael's ordered some CPS records. This is our first appearance. If we could have 30 days to complete the discovery process.
All right, just give me one moment, Mr. Ramos. I'm signing paperwork.
Sure.
All right, is your client on Zoom?
I didn't see him anywhere, Judge. He was here yesterday. And Michael just got too busy. We couldn't talk to him. So we came back this afternoon. I hadn't seen him.
All right, do you want to call him and see where he is, Mr. Ramos?
I have a 4 o'clock Zoom with another client, Judge, and I can easily go and talk with him tomorrow on the Zoom.
You want to call him and see where he is?
He's in,
Because he has
he's
a
in
court
custody.
hearing today.
He's in custody on. I'm sorry.
All right, just give me one moment.
I
Mr.
apologize.
No problem. Mr. Seeloff, I'm going to send you and your client to breakout room number 1. The clerks will meet you there and make sure that all the paperwork is completed.
Thank you very much, Your Honor.
You're welcome. And if the clerk could go to breakout room number 1, please. And let me see if I can find your client. Do you see him on screen, Mr. Ramos?
No, I looked at all of the little pictures and I hadn't seen him, Judge.
And he's a Spanish speaker too, right, Fernando?
I'm sorry?
He's a Spanish speaker, correct?
Yes, that's true, Judge.
Okay, just give me a moment.
And he's got an immigration.
All right, is your client Gilberto Sanchez?
No, it's Hector Enrique Lara Sanchez.
That's my client, Judge.
Oh, it is?
All right, who's speaking?
This is Gail Calderola, and I just have to tell you that Mr. Sanders needs time to talk to the victim, so he wants to get another reset for.
All right, so who is on this case? Is it Mr. Ramos or is it Miss Calderola?
I'm on, I was told that I'm on these cases, but I don't know.
He only has one case, Judge, that was appointed.
Yeah.
No, he had a retaliation and he has an aggravated assault with a deadly weapon.
No, that's not my guy.
Okay, that's my guy.
Okay.
Gail has Gilberto Sanchez.
Okay.
Ramos has Hector Lara Sanchez.
Okay. All right, Ms. Ferguson, so on Hector Lara Sanchez, one question for you, Mr. Ramos, is he a citizen or no?
He is got an immigration hold. He's a citizen of Honduras.
All right,
Honduras.
will you need an immigration attorney or no?
I would like to have an immigration attorney talk to him, Judge, explain all of the different conditions. If we could appoint one. Do I need to file a motion for that, Judge?
No. Ms. Ferguson, on Hector Lara Sanchez, can we recall this for May 9th and have an immigration attorney, or recall it for the week of May 9th? And we'll have an immigration attorney here. Mr. Ramos, Ms. Ferguson is saying that, yes, we can recall it on May 9th. So we're going to recall May 9th, and that's just for the immigration attorney, all right?
Not for me, Judge.
No, you will be here as well.
Oh, fair enough.
Yes. So it's going to be May 9th, and you'll get a chance to meet the immigration attorney and introduce the immigration attorney to your client.
Oh, excellent, Judge. Thank you. At 9
All right.
a.m.
Yes, 9 a.m. We'll see you then, and we will have an immigration attorney here.
Excellent, Judge. Thank you. May I be excused?
Yes, you and your client are excused.
Thank you, Judge. Good to see you.
You too. And Ms. Ferguson, if you could note on your docket that he's a Spanish speaker, please. All right, Ernest Acevedo, who do you have?
Good afternoon, Judge. Fernando Toro, I believe that's to have a dismissal turned in today on a pretrial diversion. And then Jonathan Cruz is CTD case.
All right, so Fernando Cruz, you say there's a dismissal?
No. For Fernando Toro, there's supposed to be he's been in the pretrial diversion program for months. And Michelle told me she was going to turn in a dismissal. We did have some email exchange about some of the conditions of his pretrial diversion, but that's all been handled between us, I believe. And I believe today the dismissal was going to be turned in because he's been on it for 5 months. Jonathan Cruz is a trial case with CTD that I need to see.
All right, I'll send you to number 13. We'll see if I have that dismissal.
Okay.
All right, Gail Calderola on Sanchez.
Yes, Your Honor.
The real Sanchez. Gilberto Sanchez, correct?
That is correct, Your Honor. And I conferred with Mr. Saunders, and he needs time to talk to the.
Is your client on bond? Where is
Yes, he is. He's on bond.
Gilberto Sanchez, where are you?
His emails, he was there. His email is G52021.76.
No. How's he listed on the screen?
I don't see him now. But he was there at the beginning of the hearing. I don't know if he got dropped or what happened.
All right, if you can see if you can call him to get him on screen, that will be greatly appreciated.
Okay, I can do that.
All right, thank you.
Okay. I'm gonna...
All right, Robert Porter.
Thank you, Your Honor. I have Mr. Cornelius Johnson.
Yes, have you spoken to a prosecutor yet?
I did. I just spoke to him. We'd like to just get a trial setting on that, Judge.
All right, where is your client?
I don't see his name, but I just texted him. He said he is on. Mr. Johnson, can you say something? Mr. Johnson.
All right, as soon as we get your client, we'll take that up.
Thank you, Judge.
Sylvia Cavazos, and then after Sylvia will be John Coons.
Good afternoon, Judge.
Yes.
I
Robert.
represent Brandon Sierra. And
Yes.
I've actually, even as early as yesterday or as late as yesterday, I've received a few more notices for additional discovery that I have to view at the DA's office. So we're still ironing out discovery, We'd like another setting if possible.
All right, so this is discovery you need to view at the DA's office. All right, Ms. Ferguson, can I have a 30-day reset on Brandon Sierra, please?
Friday before on Disney Junior, the first ever Disney.
All right. Well, that's not SpongeBob and SpongeBob SquarePants. All right. I'm just waiting for a date in the chat box. All right. I've been given the date of June 1st.
Hello?
All right, we'll see you back then.
Oh, yes, my honor.
All right, June 1st. And so you and Mr. Sierra are excused.
Thank you, Judge.
All right, Mr. Porter, do you have your client?
I saw him, but he wasn't the one that was walking. But I did see him.
Okay, where is your client?
Mr. Johnson, can you say something?
Yes, Robert.
There you are. Quit walking and show yourself. There you go.
Oh, okay.
All right, why is it that people come on Zoom screen? We've been doing Zoom for over 2 years and they're just not learning how to do Zoom. Is there anyone who can answer that question for me? But if anybody wants to do a TikTok video, they're able to do that. Or if anybody want to post pictures of cats, they're able to do that and look at the funny cats or film somebody who's out walking, but we can't do Zoom. So,
I had a
Mr.
mediation.
Johnson, we've had plenty of time for people to learn how to do Zoom. So this is what I'm going to tell you, and this is what I'm telling every defendant who's on this screen and every attorney. If you can't put your appropriate name in the Zoom box, you're not going to be allowed on Zoom because Zoom is a privilege. If you can't mute and unmute yourself when appropriate, your Zoom privileges are going to be suspended. If you can't show your video, your Zoom privileges are going to be suspended. Do you understand?
Yes, ma'am.
And nobody wants to go on a Disney Channel, tour with you because guess what? None of us are at home watching Disney Channel. I would love to be at home watching SpongeBob SquarePants and Hey Arnold, but I can't do it because I'm here. You understand?
Yes, ma'am.
All right, Ms. Ferguson or Mr. Johnson. Mr. Porter, are you waiting for discovery?
I've got everything. I just wanted to make sure I'm going to get the medicals from the state if I don't already have them.
All right, so do you want a jury trial?
Yes.
All right, Ms. Ferguson, can you give me a jury trial date for Mr. Cornelius Johnson? And everyone, I know some of us, when we have children, we want to live by that rule that you let them cry it out. But when you're on Zoom and you're in court, you need to pick up that baby, give that baby a bottle if that's what they want, or feed them, or change their diaper. Those are usually the 3 reasons why children cry, or either they just want to be held. And Mr. Porter, I believe you have children as well as grandchildren, so you can help your client on what needs to be done with children who are crying.
Yeah, Judge, it'll look awfully odd for me to be changing my kid diapers at their age. But I do, but I do have grandchildren.
You do. All right, Ms. Ferguson, I need a trial date on Mr. Cornelius Johnson, who is filming a movie, which is reason why he's walking from room to room. And Mr. Johnson, no matter how far you walk in your house, when children cry, I don't care if you have a 3-story home, you can always hear it. We're going to come back on June 28th for your jury trial. You need to be in court dressed for trial. Do you understand? All right, you're excused.
Thank you, Judge.
And Mr. Porter, help your client, see what the children need.
Yes, Your Honor.
Thank you.
Bye-bye.
Bye. John Kuntz.
Hey, Judge, sorry about that.
No problem.
So I have conferred with probation department, the prosecution, and my client, and there's going to be a withdrawal of the MTR, and my client will be continued on probation with some alternate amended conditions.
All right, then, Mr. Kuntz. I guess that's a happy birthday to you. Your birthday's coming up.
Not for a month, Judge. Come on, let's not age me too quickly.
Oh, that's right around the corner. All right, then you are excused.
My client is still in the breakout room. Do you want me to go back and talk to her and tell her? Because I haven't had a chance to talk to her just to confirm that everything is done or getting done.
All right, because what will need to happen, Ms. Reyes is actually in breakout room number 12 with your client. I'm assuming you're going over everything.
Perfect.
But if you want, I can move you to that breakout room.
That would be great. And thank you. And then have a nice afternoon.
Oh, thank you. You too. And have a great birth month upcoming.
Thank you.
All right. I'm trying to find, do you see what breakout room you're in, Mr. Kuntz?
We were, I believe, in 12. That sounds right.
All right. You can go to number 12.
Thank you.
You're welcome. To Ms. Calderola.
Yes, Your Honor. My client says he's there, and so if he'd just speak out.
All right, Mr. Sanchez, where are you? Mr. Sanchez.
He says he's there.
Yes, my honor.
All right, Mr. Sanchez, you have all these tattoos, but you can't work Zoom. I don't understand that.
I can't hear you, ma'am. Excuse me.
All right, Mr. Sanchez, I want you to hear this. You will not be allowed to be on Zoom anymore. This is your last time using Zoom. From here on out, you have to appear in person in court. Have you heard that?
No, ma'am. I'm sorry. I'm sorry, ma'am. I apologize. This was my first time in Zoom. I never done this before in my life. I apologize.
Mr. Sanchez, yes, apology accepted. You, from now on, will have to appear in court. Your Zoom privileges are revoked. Ms. Ferguson, can I have a 30-day reset for Mr. Sanchez? Mr. Sanchez, do not appear on Zoom again. You will have to appear in person. Do you understand?
Yes, ma'am.
So we're coming back on June 1st.
June 1st.
Ms. Ferguson, please note that Mr. Sanchez is no longer to appear on Zoom. All right, Ms. Calderola, you're excused.
Thank you, Your Honor. Have a good afternoon.
Have a great one. All right, in the courtroom, don't tear down the post.
Permission to approach, Your Honor?
Just one moment. Yes, in the courtroom.
Yes, this is James Anders for O'Seal Griffin.
Yes, have you spoken to someone?
I have. I spoke to Marcus, and he said that there is a video that is important to both sides that he believes that he is going to be able to get. And so he would like a reset for to be able to acquire that video.
Where's your client?
He said that he is on the Zoom under O'Seal Griffin. That's what he said that there he is. There's
all right, Ms. Ferguson, on Mr. Griffin, can I have a 30-day reset, please? And you said this is for videos?
Yes, ma'am. there's some surveillance video that they have said that is going to make a difference.
All right, we'll see you back on June 1st.
All right, thank you, Judge.
Thank
I'll
you.
speak
You're
with you as-
excused.
Okay, thank you, Judge.
Mr. Simmons?
Yes, Your Honor. I've conferred with my client, and you had asked us to for him to make sure that he came back before we were excused, and so we're back in the gallery, Judge.
All right, Ms. Ferguson, Mr. Debnap can go back. All right, Ronald Fenari?
Am I excused, Your Honor?
Yes, you're excused. Thank you, Mr. Simmons. Have a great rest of your day.
Yes, Judge.
Yes.
Robert Chevalier. The state requested some CPS records, so we were waiting on those. So we were
Where's your
requesting-
client?
Oh, he's in the gallery, Judge. Robert?
Yes, I'm here. Unfortunately, my camera's not working.
His camera's not working, Judge, on his device.
All right, Mr. Chevalier?
Yes, ma'am.
Mr. Chevalier,
Yes, ma'am.
your Zoom privileges are revoked. You're not allowed to use Zoom anymore. Do you understand?
Yes, ma'am.
Any case you have, you need to appear in person in court. Do you understand?
Yes, ma'am.
Yes, Your Honor.
And why is your video not working?
It's saying the camera is disabled or it can't find the camera. And I've spent the last 20 minutes trying to find it and I can't get it to work. It's just not detecting the camera.
All right, Ms. Ferguson, can you recall Mr. Chevalier in 1 month, please? All right, we're coming back on June 1st.
Thank you, Your Honor.
All right, you're excused.
Judge, I have one more, Daniel Vasquez.
All right, and Ms. Ferguson, if you'll note on the docket that Robert Chevalier is not to appear on Zoom anymore. All right, who's your other person?
It is Daniel Vasquez, Judge.
And what is happening with Mr. Vasquez?
Judge, I believe this is the first setting here, and we were asking to come back on that same day as Mr. Chevalier, 30 days.
No, this case has been around since February. So February, March, April. So what is happening? And it shows that the discovery acknowledgement has been signed.
Okay, Judge, if I can confirm briefly one more time, I thought that there was some more discovery that we were waiting on.
Okay, I will send you to a breakout room.
Okay, thank you, Judge.
You're welcome. I will send you. I'm going to send you to breakout room number 2.
Okay, thank you.
All right, is there a prosecutor available for Mr. Avalos for a plea?
I can step in, Judge Joe Ray.
All right, thank you.
Stay still, Mr. Avalos. You're next. Don't
All
move.
right. Court is calling 2022 CR 2228, State of Texas versus Eric Avalos. Can I have parties announced for the record for the state?
Joe Ray Garcia.
For the defense?
James Seeloff for the defense.
And are you Mr. Avalos?
Yes, ma'am.
We're proceeding by video due to the pandemic. Any objection from the state or the defense?
I'm from the state.
No objection.
Mr. Avalos, I'm showing you what's entitled defendant's consent to appear by video. Did you review that document with your attorney? Did you understand it and did you electronically sign it?
Yes.
Court will find that defendant has knowingly and voluntarily consented to appear by video. Showing you what's entitled application for deferred adjudication or community supervision. Did you review that document with your attorney? Did you understand it and did you sign it?
Yes, ma'am.
Counsel, I'm showing you the discovery acknowledgement. Have you received all the discovery in this case and did you review it with your client?
Yes, I have.
Court will find that the state is in compliance with discovery. Mr. Avalos, I'm showing you what's entitled True Bill of Indictment. Did you review that document with your attorney? Did you understand it?
Yes.
Counsel, do you waive the reading of the indictment?
We waive, Your Honor.
State, it appears that you are waiving count one. Is
No,
that correct?
We're going on count one, waiving count two.
All right, that's not what the plea agreement says. It says that the prosecution
Should
is
be in
to
a,
proceed on count two.
It should be count one, the striking, the choking, count one, as opposed to the pregnancy count two. Two different victims. And
All right, well, there's an
agreed to
issue
count one.
because the documents that the court has, it says assault of a pregnant person.
It should be count one, Your Honor. I'm sorry for any confusion.
Oh, no problem. What I'll do is I'll send you back to a breakout room with the state and we'll see if we can figure out what the issue is.
Thank you very much, Your Honor.
You're welcome. I'm going to send you to breakout room number 3.
Okay, thank you very much.
No problem.
And Judge, can you please let me know who the attorney was on that plea agreement so I can reach out to them? and verify?
Yes.
Thank you.
Michelle Hayden.
Okay, I'll let her know. Thanks.
All right, thank you. All right, Nathan Slimane.
Good afternoon, Your Honor. We're working on paperwork. We have an agreement on Mr. Pinelli.
All right, thank you.
Yes, ma'am.
Do you need to be in a breakout room with your client?
I just left a breakout room with my client.
All right, thank you.
Thank you, Judge.
Teresa Conley.
Yes, good afternoon.
Good afternoon.
I have originally Michelle was the DA, but she got called to a meeting. So I dealt with Mike a little bit and he said I should ask for a 2-week continuance. We're close. We have a possibility here.
All right, just one moment. And where is your client?
John Carlo, I did see him earlier, John Carlo Armstrong.
Yes, I'm here.
You there?
Yes, ma'am.
There he is.
All right, Ms. Ferguson, can I have a 2-week reset on John Carlo Armstrong, please? All right, we're going to come back on May 16th.
May 16th, afternoon or morning, Your Honor?
That will be morning, and I'll show it as set for disposition.
Thank you. Disposition in the morning on May 16th. Thank you, Your Honor. May we be excused?
Yes, you're excused.
Thank you.
You're
I'll
welcome.
call you, John.
Everyone, just give me one moment, please. Yes. Hi, everyone.
Hey there.
Yes, Mr. Seeloff and then Mr. Cantrell.
You're on mute.
I'm here, Judge.
Yes.
The DA was Joe Ray.
Ah, okay. Well, I mean, what is happening with your case, though?
He said that he's going to make a oral amendment to you, and he's okay with it. I'm okay with it.
All right, just give me a moment and we will take that up. Anthony Cantrell?
Judge, we're waiting on the certificate of appeal, and then we'll be ready to go on Monique Williams.
All right, thank you. Anton Hayek?
I am here, Your Honor. I have two matters. Emily Casillas is on your screen. That's going to be an amended conditions, continue with ISP.
Okay, just give me a moment on that.
Certainly.
Thank you. I appreciate everyone's patience. We are working as fast as we can. All
Well,
right.
we appreciate your work as fast as you can.
All right, so we're going to go back on the record, Brenna, on Mr. Eric Avalos. Are you ready?
Yes,
Brenna?
we're ready. Eric, stand still.
No. The most important person of this is the court reporter.
I'm here, Judge.
Yes.
All right, thanks.
Thank you, ma'am.
All right, so we're back on the record on 2022 CR 228, State of Texas versus Eric Avalos. So state, is there a motion
The
as
last
it
2
relates
hours.
with regards to the?
Yes, Your Honor, there is. We'd like to amend, we're going on count 1 of the indictment, waiving count 2.
All right, any objections from the defense?
No objection, Your Honor.
And are you proceeding on the first one, which is assault, choking, strangulation as a 3rd-degree felony, Mr. Garcia?
Yes, Your Honor, we are. And I realize that changes the judicial confession. Would you like me to read the language in?
Yes, just give me one moment.
Okay.
All right, and with regards to the judicial language, Mr. Garcia?
Yes, on count 1 in the indictment, it reads, on or about the 8th day of August, 2021, Eric Avalos, hereinafter referred to as defendant, did intentionally, knowingly, and recklessly cause bodily injury to Jane Doe, a pseudonym, a member of the defendant's family, household, or a person who the defendant has or has a dating relationship, hereinafter referred to as the complainant, by intentionally, knowingly, or recklessly impeding the normal breathing or circulation of the blood of the complainant by applying pressure to the throat or the neck and blocking the nose or mouth of the complainant.
Any objections?
No objection, Your Honor.
Any objections to the court having the document reflect that language in writing?
No objection.
Then just give me a moment, because I must now write that in.
Eric, we're proceeding on count 1.
All right, Mr. Avalos, I'm going to show you what's entitled Court Admonishments and Defendants Waivers and Affidavit of Admonitions. Did you review that document with your attorney? Did you understand it? Did you electronically sign it in all the appropriate places?
Yes, ma'am.
Did you understand you're charged with assault, family choking, and strangulation? That's a third-degree felony. The range of punishment is anywhere from 2 to 10 years in prison and up to a $10,000 fine.
Yes, ma'am.
Did you understand if you have a plea bargain agreement with the state, the court does not have to follow your plea bargain agreement? If for any reason the court does not follow your plea bargain agreement and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes, ma'am.
Did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state will call, and the right to remain silent?
Yes.
Did you understand by entering this plea bargain agreement, you were giving up those rights?
Yes, ma'am.
Did you intend to give up those rights and enter into a plea bargain agreement in this case? Did you intend to give up those rights and enter into a plea bargain agreement in this case?
I mean, I didn't intend to do any of this. But I'm complying. I want to proceed.
Mr. Avalos, could you please listen to my question and answer the question that's asked of you?
Yes.
The question I'm asking of you is, did you intend to give up those rights that I explained to you and enter a plea bargain agreement in this case? That's either yes or no.
Yes.
Did you understand if the court were to grant your application for deferred adjudication, if for any reason your deferred adjudication were revoked, the court could sentence you up to 10 years in prison and up to a $10,000 fine? Did you understand?
Yes.
Counsel, has your client been able to provide you with any defenses to this offense?
Yes, he has.
Do you believe he has a rational as well as a factual understanding of the charges against him?
I believe he does.
Do you believe he's currently competent and was legally sane at the time of the offense?
I believe he was.
Mr. Avalos, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No, ma'am.
Has anyone promised you anything other than the plea bargain agreement to get you to enter this plea?
No, ma'am.
Are you satisfied with the way you've been represented?
Yes.
Are you a U.S. citizen?
Yes, ma'am.
Court will find that the defendant has knowingly and voluntarily waived his right to jury trial. Next, I'm going to show you what's entitled the plea bargain page. Did you review that page with your attorney? Did you understand it?
Yes.
According to the plea bargain agreement, the state is proceeding on count 2. They're asking that your punishment be assessed at a $1,500 fine. They recommend deferred adjudication. Will take in consideration cause number 625175. There's an affirmative finding of family violence, no harmful or injurious contact with the complainants or victims in this case, the BIPP course and parenting classes, and a mental health evaluation. Did you understand those are recommendations from the state and the court does not have to follow those recommendations?
Yes, ma'am.
Then to the, did you understand with an affirmative finding of family violence, you're not allowed to own or possess any weapons or ammunition?
Yes.
Did you understand with an affirmative finding of family violence, you're not allowed to be designated as primary custodial parent?
Yeah. Yes.
Did you understand that to be the entirety of your plea bargain agreement?
Yes, ma'am.
Defense, is that the plea bargain agreement?
Yes, it is.
State, is that the plea bargain agreement?
Yes, Your Honor.
Next, I'm showing you what's entitled waiver of appeal paragraph. Did you review that paragraph with your attorney? Did you understand it? And did you sign it in both places?
Yes.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes.
Counsel, have there been any such motions?
No.
Next, I'm showing you outside the plea bargain agreement. The state is requesting that your deferred adjudication be for a term of 4 years. There be a TAP evaluation and 150 hours community service restitution. Did you understand those were recommendations from the state and the court does not have to follow those recommendations?
Yes.
Then how do you plead to count one in the indictment? Guilty, not guilty, or no contest?
Guilty.
State any evidence to support the defendant's plea.
It offers State Exhibit 1, its attachments.
No objection, Your Honor.
Mr. Avalos, I'm showing you what's entitled Wavering Consent to Stipulation of Testimony and Stipulations. Did you review that document with your attorney? Did you understand it? Did you electronically sign it in all the appropriate places?
Yes, ma'am.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses? The state will call them the right to remain silent.
Are you still there, Eric?
Sorry, we electronics.
Did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state will call them the right to remain silent?
Yes, ma'am.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there will be no live testimony? Did you understand?
Yes.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence State's Exhibits 1 and attachments and review the same.
No objection.
All right, after reviewing State's Exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty. However, the court will defer finding of guilt as you've applied for deferred adjudication. Are you proceeding with sentencing?
Yes, Your Honor, we waive pre-sentence investigation.
Anything you wish to say on behalf of your client?
I only wish to state that my client is court appointed and he is working currently. So I ask the court to take that into consideration as to the fine and the community service hours. Thank you
All right,
very much.
Mr. Avalos, what do you do for a living?
I make sandwiches at Subway.
All right, do you do that with or without a hairnet?
With a tongo. They don't require us to use hairnet anymore. You just have to tie it up.
Okay. All right. $1,500 fine, probated. 4 years deferred adjudication. Affirmative finding of family violence. Take in consideration 625-175. When's the last time you had contact with your sister?
Since the incident.
So there's to be no harm for or injurious contact with the complainants in the case. If you're drug tested today, what are the results going to be?
Positive for marijuana.
And what else?
That's it.
All right, you can't use drugs when you're on probation, Mr. Avalos, even if it is marijuana.
Yes, ma'am.
And don't let any of that accidentally drop in any sandwiches. You understand?
Absolutely.
All right, the BIPP course. Do you have children?
Yes, I have a 4-year-old and a newborn.
They're going to be parenting classes. Is Child Protective Services involved?
Currently, no.
Have they been in the past?
Yeah, they were involved because of this case. And upon interviewing Leandra Bell, they established that she's very problematic and disrespectful and stuff like that. And so they they dropped the CPS case.
How often do you see your children?
Every day.
Do they live with you?
Yes, ma'am.
All right, this is what the court is going to do. As previously stated, a $1,500 fine, probated, 4 years deferred adjudication, affirmative finding of family violence, taking consideration 625175, no harmful or injurious contact with the complainants, the BIPP course, parenting classes, CPS compliance if applicable, MIC evaluation, 150 hours of community service restitution. 40 of those hours will be waived if you provide proof of the COVID vaccination. Court is not requiring you to get the COVID vaccination, but if you do, 40 of those hours will be waived. You must complete parenting classes. If you complete when you complete the parenting classes, the remaining of the community service hours will be waived. There's to be regular reporting by Zoom or in person. So if for some reason you can't report by Zoom, you need to do it in person. I'm going to want him tested for levels. Those levels need to start coming down. And we're going to do field visits 2 times per month, random. And Ms. Reyes, please have them check to see how the children are doing. Is there anything else that he needs, Ms. Reyes?
A proof of employment, Judge.
Thank you. Proof of employment within 15 days. And there should be no employment as a home health care provider or with minors. And make sure that lettuce is not wilted.
Yes, ma'am. I am passionate about Subway. I operate the best running Subway in this city.
Okay, awesome. I'm going to take you up on that. I'm showing you what's entitled Trial Court Certification of Defendant's Rights to Appeal. Did you review that with your attorney? Did you understand it? And did you sign it?
Yes, ma'am.
Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Do you understand?
Yes.
Because this is an affirmative finding of family violence, you're not allowed to own or possess any weapons or ammunition. Do you understand?
Yes, ma'am.
All right, Mr. Seeloff, I'm going to
Yes, Your
depend on
Honor.
you to check out the sandwiches at Subway where he works, and then I'll try it after you.
Oh,
where's
you-
Bob?
Okay.
Where's it
Where's Bob?
located? Okay.
Where's Bob? Let me see.
Eric, you have to stand by and talk to the probation officer. Stand by, stay on Zoom, please.
Yes, sir. Yes,
All right,
sir.
I'm going to send you to breakout room number 4. Probation will speak to you there.
Thank you
Thank
very
you.
much, Judge. Joe Ray,
Thank
send me proof
Yeah.
of the rejection of County Court 8.
May I
Okay,
approach, Your Honor?
Thank you.
Thank
Thank
you.
you very much, Judge. May I be excused?
you're excused. And Mr. Avalos, you need to go to breakout room number 4. Probation will meet you there and go over conditions.
Okay, thank you, Your Honor.
You're welcome, Mr. Wood.
Thank you, Judge.
Judge, I apologize. I've got a client named Regina Hedricks. I spoke with Marcus. He tells me she's a fugitive. There's been a warrant since April 6th.
Yes.
She apparently has 3 cases, apparently hired Joseph Acevedo on 2, and I'm on the 3rd case, and I think he's her bondsman as well. I think that's how it started. I think she hired him as a bondsman, and then he became her attorney on the MTR and the 3rd degree.
All right, well, she's a fugitive from justice, so that means that Tommy Lee Jones just is an actor. Cornelius, I think you're the only person who gets that reference.
The youngsters, they don't know what we're
They
talking
don't
about.
know. All right, then we will see if we can locate Miss Hendricks.
Thank you,
But
Your
there
Honor.
should be a warrant out for her in each of these cases.
I will search. I wanted you to know I was in a mediation yesterday, and the mediator was not conversant with Zoom. She was uncomfortable with Zoom, so we did it by telephone. There were 11 people doing a mediation by phone.
Oh my gosh.
Yeah, that's what all of us said. What? Now what now? So I thought it was 1950.
All right, you're excused. And Mr. Eric Avalos, you are in that breakout room. All right, thank you, Mr.
Thank you,
Wood. Tell
Judge.
your
Thank-
mom I said hi. She's
Oh, thank you very
over
much.
100 years old. That's awesome.
101.
All right, have a good one.
Thank you.
All right, May Garza.
Yes, Judge, I'm here for Mario Gonzalez. And I spoke to the state and they need additional time to confer with their witness. And so we're just getting a reset, Judge.
All right. Oops.
My client's in the court. His name is Mario's iPhone.
No, I think Mario changed his name on his phone after I made the announcement.
Yes, ma'am.
All right, Ms. Ferguson, can I have a 30-day reset on Mr. Gonzalez, please? All right, we're going to come back on June 1st.
Thank you, Judge. May we be dismissed?
Yes, you're excused. Thank you for your patience.
Thank you.
You're welcome. Mr. Cox?
Yes, Judge.
Yes.
I have, my client's name is Sant Wilson.
Oh, Santon Wilson. Yes.
Santon Wilson.
What is
And I
happening,
need
Mr. Wilson?
I just recently been appointed to the case, Judge. I'm a new lawyer on it. And I just need to confer with the state and I need a reset for discovery purposes.
All right. So, Mr. Cox, have you talked to the state today at all?
No, ma'am. I've been I have patience in my pocket, Judge.
All right.
Any way I can excuse Mr. Wilson? He's been on since
2 o'clock.
Yeah, and he's still here. So if any way I can, I'm
All
gonna
right,
ask her to be
Mr.
reset for
Cox, I
discovery
would
purposes.
love to offer to do that. However, I've been on Zoom since 9.
Yes, ma'am.
All right. So, Mr. Cox, I'm going to send you to breakout room number 5. Prosecutor will speak with you, and then we will see about dates. Mr. Wilson, just remain on. Jonathan Chavez.
Yes, Your Honor. I'm here on Victor Rivas, and I conferred with Ryan Groomer. He's getting me some more discovery from the labs.
All right. And is your client in custody or on bond?
He's on bond, and he's on, Your Honor. He's under Victor. I saw him just a little bit ago. I don't see him right now, but he was logged on under Victor.
Victor Rivas. All right, Ms. Ferguson, can I have a 30-day reset on Victor Rivas, please? All right, we're going to come back on June 1st. Okay. Be sure to let your client know that his Zoom privileges are revoked. So he'll have to appear from here on out in person.
Okay, thank you, Your Honor.
You're welcome.
Maybe
right. Yes, you may be excused. Everyone just give me a All right, Michael Goins.
Yes, Your Honor, I'm here on Mr. Paul Lavana.
Yes, what is happening?
I spoke with Joe Ray. He made me an offer, and I'd like some time to discuss with my client. He is on, Your Honor, I believe. I don't see his fingers on my phone, but I believe he is in the Zoom meeting, Your Honor.
Yes, he's here. All right, Ms. Ferguson, on Mr. Luvano, can I have a 2-week reset, please? All right, Mr. Lugano, we're going to come back on May 9th. Make sure you're clean. Do you understand?
Yes, ma'am.
I'll call you right after this, Paul.
Sir.
All right, you're excused.
Thank you, Your Honor.
You're welcome. All right, and who's in the courtroom?
Hello, Your Honor. This is Carlos J. Vargas. I'm approaching
Yes.
regarding motion requesting permission to travel.
All right, who's your attorney?
Oh, I'm the attorney, Carlos J. Vargas.
Oh, I'm so
Oh,
sorry.
Don't worry.
I haven't seen you before. Are you
I'm-
from San Antonio?
I am. I'm from Puerto Rico. I've been living in San Antonio for the past 4 years.
All right, who's your
I
client?
recently made it to the practice, so I'm new here.
All right, who's your client?
All right, it's gonna be Diego Antolines.
All right, does your client have other criminal history?
No, no prior.
All right, then he can go travel.
All right, thank you, Judge.
You're
Can I be
welcome.
excused?
Yes, you may be excused.
Thank you. Appreciate it.
Sure. Ronald Funari.
Yes, Your Honor, I'm back. We're going to need a trial date, Judge.
And that's for Vasquez?
Yes, Your Honor.
All right, did you leave Mr. Vasquez in a breakout room or is he listed as something else?
He was under his name, Daniel Vasquez. But I am not seeing him in here.
All right, you want to call your client and try to figure out where he is?
Yes, Judge, I'll get him back.
Thank you.
Thank you.
Anthony Cantrell, do you know if the paperwork is done?
Judge, I'm working on it right now. We should be done in just a couple minutes.
All right, thank you. Arlene Gay?
Hi, Your Honor. I've conferred with Michael Villarreal. And part of coming here today was regarding a bond condition. That's before the court, if you have the paperwork. But we were just trying to let her, she's on GPS tracking, and let her to come to Bexar County to run household errands since the complaining witness doesn't live in Bexar County anymore. And Mr. Villarreal did not have a problem with that.
All right, if you send me the agreed order, the court will sign it.
Okay, and I believe that there's just an update on discovery. Mr. Villarreal and I did discuss that. And he just received CPS records this morning.
And I'm
So
sorry,
he
what is your client's name?
Aaron Strauss.
And Miss Gay, I see your order. And I'll just place agreed at the top of it.
Thank you, Your Honor.
All right. And then Ms. Ferguson, can I have a 1-month reset on Aaron Strom, please? All right, we'll be back on June 1st.
Thank you, Your Honor. Have a good afternoon.
Thank you, you too.
Okay, bye-bye.
All right, Joseph Stateson.
Hello, Judge. I finished conferring with ADA Michael. This is for Monica Guerrero's client, Nancy. This is a complicated case with civil agreed temporary orders, final orders, stemming from a divorce in Guadalupe County.
Yes.
Michael Monica and I all agree more time to confer is necessary on this case if we can come back for another setting.
All right, how much time are you all asking for?
Just 30 days, Your Honor.
All right, Ms. Fergus, can I have a 30-day reset on Ms. Fernandez-Graham, please? All right, June 1st.
All right, thank you, Judge. May Ms.
You're
Graham
welcome,
and I
you're
be
excused.
All right, thank you. Ms. Graham, you can disconnect Zoom. Monica will reach you.
All right, and for Ken Baker.
Hi, Judge. I'm still waiting to confer. I think Norma's trying to get me with somebody.
All right, thank you. Ernest Acevedo.
Hello, Judge. I've conferred with Ms. Hayden. We do have an agreement to dismiss that case for Mr. Toro, and we have exchanged emails detailing all the requirements for him to be in continued compliance with this pretrial diversion.
All right, so as soon as the court receives that, then the court will sign it.
All
Did
right.
you have another case?
I do have Jonathan Cruz Garcia, Judge. I don't know if that's with Marcus or with Ryan. I've tried texting Ryan, but I haven't gotten a hold of him.
All right. All right, Jonathan Cruz Garcia. Ms. Ferguson, let's bring that back in 2 weeks, please. So we're going to come back on May 9th.
That'd be fine with me, Judge.
All right, thank you. You're excused.
Thank you. Is Mr. Toro excused as well, Judge?
Yes, and just make sure you double check to make sure that I've received that dismissal.
We will do. Thank you very much.
Thank you.
Thank you, Judge.
You're welcome. Bye-bye. Mr. Cox?
Yes, Your Honor. I spoke with Marcus, and he informed me that all the discovery has been uploaded, so I have an opportunity to review it, and he'll at that point he'll give me make some type of offer to me.
All right, Ms. Ferguson, if you can reset Mr. Wilson for 90 days, for 30 days.
90 days? I'll take it, Judge.
30 days, and that's going to be your, the state will give you an offer at that time.
Okay. Thank you, Judge.
So we're going to come
you
back
don't want to go 90 days with me?
We're gonna come back on June 1st.
June 1st. All right, thank you, Judge. We will, may we be excused?
Yes, you're excused.
All right, thank you, Judge.
You're welcome. You're welcome. Anyone ready?
Judge, our paperwork should be turned in by now. I don't, if you could
Your
check.
Honor, I believe Hagg's still ready on this Diaz.
All right, I'm just waiting for that paperwork to come to me.
Judge, can you put me in the breakout room with Monique Riley?
All right, Monique Rowley. If you go to breakout room number 1, Anthony Cantrell, go to 1. The clerks are going to meet you in 1. Anton Haig, I'm sending you to 1. Where is your client, Temez?
I don't know. He was.
I'm here, ma'am. I'm still here.
Your Galaxy, I'm
Yes,
sending
ma'am.
you to breakout room number 1.
Breakout room number 1.
Yes.
Miss Casillas is an alternate amend.
All
I don't
right.
believe there's paperwork.
Is the state withdrawing that motion?
No, it's the plea on a,
All right, Ms. Ferguson, can you get plea paperwork to Emily? She's listed as 16A for consent to enter a plea, please.
Okay, thanks, Judge.
And Emily, I'm sending you to breakout room number 1 as well. All right, and the clerk is at number 1 saying that they don't have discovery for Riley. So if there's a prosecutor who has discovery for Riley Williams, please.
Judge, I sent you a text.
Okay, thank you. It's been that type of week. All right, thanks for letting me know. Yes, what is your name, sir? He keeps waving to me. You're on mute.
Jonathan Cedillo,
Who's your attorney?
Robert E. Mauer.
All right, just give us a moment.
Yes, ma'am.
All right, Ms. Ferguson, can I have a jury trial date for Mr. Cedillo? All right, your jury trial date is going to be May 9th. You'll need to appear in person on that day. Do you understand?
Yes, ma'am.
All right, you're excused. You'll need to appear in person in court.
Yes, ma'am.
Thank you.
You're welcome.
Judge, I sent you a chat.
Yes, thank you. Thank you. All right, we're ready on Raleigh.
We're ready, Your Honor.
All right, court is calling 2022 CR 11076, State of Texas versus Monique Renee Raleigh. Can I have parties announced for the record for the state?
Michael's case.
I can jump in. I'm not sure where Michael is.
Okay. All right. For the state?
Joey Garcia.
For the defense?
Anthony Cantrell.
We're proceeding by video due to the pandemic. Any objection from the state?
No, Your Honor.
Any objection from the defense?
No, Your Honor.
Ms. Raleigh, I'm showing you what's entitled defendant's consent to appear by video. Did you review that document with your attorney? Did you understand it? Did you sign it?
Yes, ma'am.
Next, I'm showing you what's entitled application for deferred adjudication. Did you review it with your attorney? Did you understand it? Did you sign it?
Yes, ma'am.
Counsel, I'm showing you what's entitled discovery acknowledgement. Have you received all the discovery in this case? Did you review it with your client?
Yes, Your Honor.
Court will find that the state is in compliance with discovery. The court will find that defendant has knowingly and voluntarily consented to appear by video conference. I'm showing you, Ms. Raleigh, what's entitled true bill of indictment. Did you review that document with your attorney? Did you understand it?
Yes, ma'am.
Counsel, do you waive the reading of the indictment?
Yes, Your Honor.
State, it appears that you're proceeding on the indictment as presented. Is that correct?
Yes, Your Honor.
Ms. Williams, I'm showing you what's entitled court admonishments and defendant's waivers and affidavit of admonitions. Did you review that document with your attorney? Did you understand it? Did you electronically sign it in all the appropriate places?
Yes, ma'am.
Did you understand you're charged with deadly conduct firearm? That's a third-degree felony. The range of punishment is anywhere from 2 to 10 years in prison and up to a $10,000 fine. Did you understand?
Yes, ma'am.
If you have a plea bargain agreement with the state, the court does not have to follow your plea bargain agreement. If for any reason the court does not follow your plea bargain agreement and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes, ma'am.
Did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state will call, and the right to remain silent?
Yes, ma'am.
Did you understand by entering this plea bargain agreement, you were giving up those rights?
Yes, ma'am.
Did you intend to give up those rights and enter into a plea bargain agreement in this case?
Yes, ma'am.
Did you understand if the court were to grant your application for deferred adjudication, if for any reason your deferred adjudication were revoked, the court could find you guilty and sentence you up to 10 years in prison and up to $10,000 fine? Did you understand?
Yes, ma'am.
Counsel, has your client been able to provide you with any defenses to this offense?
Yes, Your Honor.
Do you believe she has a rational as well as a factual understanding of the charges against her?
She does.
Do you believe she's currently competent and was legally sane at the time of the offense?
Yes, Your Honor.
Ms. Raleigh, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No, ma'am.
Has anyone promised you anything other than the plea bargain agreement to get you to enter this plea?
No, ma'am.
Are you satisfied with the way you've been represented?
Yes, ma'am.
Are you a U.S. citizen?
Yes, ma'am.
The court will find that the defendant has knowingly and voluntarily waived her right to jury trial. Showing you the plea bargain page. Did you review that page with your attorney? Did you understand it?
Yes, ma'am.
According to the plea bargain agreement, punishments be assessed at 8 years in the prison. There's a $1,500 fine. The state opposes your application for community supervision or deferred adjudication. They will take in consideration 2021 CR 10892 and County Court Cause number 680625. Did you understand that to be the plea bargain agreement?
Yes, ma'am.
Defense, is that the plea bargain agreement?
It is, Your Honor.
State, is that the plea bargain agreement?
Yes, Your Honor.
Next, I'm showing you what's entitled waiver of appeal paragraph. Did you review that paragraph with your attorney? Did you understand it? And did you electronically sign it in both places?
Yes, ma'am.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, ma'am.
Counselor, have there been any such motions?
No, Your Honor.
Then to the offense as charged in the indictment, how do you plead? Guilty, not guilty, or no contest?
No contest.
State any evidence to support the defendant's plea.
State offers States Exhibit 1 and its attachments.
Any
No
objections?
objection.
Ms. Riley Williams, I'm showing you what's entitled waiving consent to stipulation of testimony and stipulations. Did you review that document with your attorney? Did you understand it? Did you electronically sign it in all the appropriate places?
Yes, ma'am.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call and the right to remain silent?
Yes, ma'am.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there will be no live testimony? Did you understand?
Yes, ma'am.
Court will find that the defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept in evidence States Exhibits 1 and attachments, and the court will review the same. After reviewing States Exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty. Court will defer finding of guilt as you apply for deferred adjudication. Ms. Ferguson, I'll need a PSI date, please. And defense, do you plan on calling witnesses?
Yes, Your Honor.
Ms. Ferguson, there will be witnesses.
And Judge, will that be live?
Yes.
Okay.
But your client can be by Zoom, and you can be by Zoom if you choose to.
Okay.
So are you requesting a Zoom as opposed to being in person?
Well, let me make sure I understand this. I'm required to be there, but my client's not, or
You
I
all can be
request
on Zoom. No, you all can be on Zoom if you so choose.
That's fine. Then I'd like to do it by Zoom then.
All right. So Ms. Ferguson, what date? All right, Ms. Ferguson is telling me July 11th. And that will be at 2 p.m.
Thank you, Judge.
Thank you.
Bye-bye.
Bye-bye. Norma, you can let them know Ms. Williams can go back.
Judge, I need to get information from her.
Thank you. All right, Ms. Reyes, I'll send you to number 2. Ms. Williams, I'll send you to number 2. And Rebecca, go ahead and do a TAP evaluation as well.
Yes, ma'am.
Thank you. So we're just waiting on paperwork on Pinelli, Brenna. Ms. Ferguson, I see Mr. Ivy. I guess he's still being held in Maverick County. Is that correct?
Judge, when I looked at it, he appeared to be either Maverick or Valverde County. He had warrants for both of those with the United States Marshal Service. And it looks like he does have 2 cases pending. I'm trying to get more information about the status of those cases, but it looks like what I can tell so far, they're still pending.
All right, Ms. Ferguson, can I do a 45-day reset on Mr. Ivy? And everyone needs to try to locate Mr. Ivy and see if we can get him here by Zoom.
Yes, Judge.
All right, so we're gonna come back on June 27th. And Michelle, I signed that dismissal.
Thank you, Your Honor.
All right, Mr. Rivera.
Yes, ma'am.
All right, I believe you're Arturo Francisco Rivera, is that correct?
Yes, ma'am, that is correct.
All right, Ms. Ferguson, can I have a 30-day reset on this case, please? And put it for a jury trial. June 27th, is that the date, Ms. Ferguson? Oh, no, that's not the date, okay. All right, you're coming back on May 17th.
Thank you.
All right, you're welcome. Oh, yes, give me one moment. All right, bye-bye. Who are the parties on Emily Casillas?
Hayek represents her, Your Honor.
All right, the court is calling 2021 CR 02518, State of Texas versus Emily Casillas. Can I have parties announced for the record for the state,
Joey Garcia.
for the defense?
Anton Hayek.
All right, are you Ms. Casillas?
Yes, ma'am.
We're proceeding by video due to the pandemic. Any objection from the state or the defense?
None, Your Honor.
Ms. Casillas, I'm showing you what's entitled Defendant's Consent to Appear by Video. Did you review that document with your attorney? Did you understand it? Did you sign it?
Yes, ma'am, I did.
Court will find that defendant has knowingly and voluntarily consented to appear by video. Next, I'm showing you what's entitled Motion to Revoke Community Supervision and State's Motion to Supplement pending motion to revoke probation. Did you review those documents with your attorney? Did you understand them?
Yes, ma'am, I did.
Are you the same Emily Christine Casillas who is placed on community supervision in cause number 2021 CR 02518 for the offense of possession of a controlled substance, penalty group 1, less than 1 gram, on April 7, 2021 for a term of 2 years? Is that you?
Yes, ma'am, that's me.
All right, state.
Violated condition on state supplemental motion, violated condition number 5 in Bexar County, Texas, the defendant Emily Christine Casillas did then and there fail to report to the supervision officer as directed for the months of October, November, and December 2021 in violation of condition number 5.
How do you plead to that, true or not true?
True.
True, Emily.
State waives the remaining allegations, Your Honor.
Any objections to the state's waivers?
No objections.
All right, Ms. Casillas, did you understand by pleading true to violation condition number 5, court could find it true, grant the motion, sentence you to up to 180 days in the state jail facility, and up to a $100 fine? Did you understand?
Yes, ma'am, I did.
Knowing that, do you still wish to plead true to violation condition number 5?
Yes.
Court will find violation condition number 5 true. Is there an agreement?
Yes, Your Honor. We are requesting probation's recommendation, which is to deny the motion, alter and amend conditions for ISP supervision and weekly drug testing for the next 90 days.
That's our agreement, Your Honor.
All right. This is what the court is going to do. Deny the motion, alter and amend conditions to include ISP, the UA hotline until further notice, field visits, random, 1 time per month. Anything else from either side?
Nothing from state.
Nothing for the defense, Your Honor.
All right, Ms. Casillas, you need to do better. I'm going to send you to breakout room I'll send you to breakout room number 2. Probation will go over conditions with you. Good luck to you.
Thank you. You have a good day, ma'am.
Thank you, you too. Who's the attorney for Sharona Williams? Ms. Williams, who is your attorney?
I am, Your Honor.
Hi, what is happening with this case?
Well, I met with Michelle, and she told me to tell you that it had not been coded right. They would like a chance to reach out to their complainant.
Okay, so is this not a family violence?
It is a family violence. They just weren't aware, I believe, Judge.
All right, Ms. Ferguson on Sharona Williams, can I have a 30-day reset? All right, we'll come back on June 1st.
Okay, thank you, Your Honor. Have a great weekend if I don't see you.
Thank you, you too. Bye-bye.
Bye-bye.
All right, Ms. Williams, you're excused. All right, who's your attorney, Mr. Kevin Castillo?
Your Honor, I hired Jesse Rivera.
All right, we're going to have you come back on May 9th.
Thank you, Your Honor.
You need to let your attorney know that they need to be here.
I'll let him know that. Is that morning or at 2?
That's in the morning at 9.
All right, thank you.
You're welcome. Nathan Slemaine, have you finished with your paperwork?
Yes, Your Honor, everything's been submitted. It should be with the clerk. Mr. Pinelli needs to be sworn, and if Mr. Sanders is available, I think we're ready to proceed.
Okay. And then your case, Mr. Hayek?
My paperwork is with, Guadalupe, and he had something else to do with it.
All
I
right,
think we
thank you.
signed everything.
All right, he's just handed it to me, Mr. Hayek.
That's fine, thank you.
You're welcome. All right, court is calling. Let's see if I can find your person just a second. All right, where is Thomas? Joe Anthony Thomas. You need to unmute, sir.
I'm here, ma'am.
All right, court is calling 2022 CR 3270, State of Texas versus Joe Anthony Thomas. Could I have parties announced for the record for the state,
Joe Ray Garcia.
for the defense?
Anton Hayek for the defense.
All right, are you Mr. Thomas?
Yes, ma'am.
We're proceeding by video due to the pandemic. Any objections from the state or the defense?
No objection from the defense.
Mr. Thomas, I'm showing you what's entitled defendant's consent to appear by video. Did you review that with your attorney? Did you understand it? Did you sign it?
Yes, ma'am.
Showing you the application for community supervision. Did you review that with your attorney? Did you understand it? And did you sign it?
Yes, ma'am.
Counsel, have you received all the discovery in this case, and did you review it with your client?
Yes, I have, Your Honor.
Court will find that the state is in compliance with discovery. The court will find that defendant has knowingly and voluntarily consented to appear by video. Mr. Thomas, I'm showing you what's entitled True Bill of Indictment. Did you review that document with your attorney? Did you understand it?
Yes, ma'am.
Counsel, do you waive the reading of the indictment?
We waive the reading of the indictment, Your Honor.
State, are you proceeding on the indictment as presented?
Yes, Your Honor.
Mr. Thomas, I'm showing you what's entitled Court Admonishments and Defendant's Waivers and Affidavit of Admonitions. Did you review that document with your attorney? Did you understand it? Did you electronically sign it in all the appropriate places?
Yes, ma'am.
Did you understand you're charged with felony in possession of a firearm? That's a third-degree felony. The range of punishment is anywhere from 2 to 10 years in prison and up to a $10,000 fine. Did you understand?
Yes, ma'am.
If you have a plea bargain agreement with the state, the court does not have to follow your plea bargain agreement. If for any reason the court does not follow your plea bargain agreement and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes, ma'am.
Did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state will call, and the right to remain silent?
Yes, ma'am.
Did you understand by entering this plea bargain agreement, you were giving up those rights?
Yes, ma'am.
Did you intend to give up those rights and enter into a plea bargain agreement in this case?
Yes, ma'am.
Did you, Mr. Hayek, has your client been able to provide you with any defenses to this offense?
Yes, he has, Your Honor.
Do you believe he has a rational as well as a factual understanding of the charges against him?
I so believe, Your Honor.
Do you believe he's currently competent and was legally sane at the time of the offense?
I do so believe, Your Honor.
Mr. Thomas, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No, ma'am.
Has anyone promised you anything other than the plea bargain agreement to get you to enter this plea?
No, ma'am.
Are you satisfied with the way you've been represented?
Yes, ma'am.
Are you a U.S. citizen?
Yes, ma'am.
Court will find that the defendant has knowingly and voluntarily waived his right to jury trial. Showing you the plea bargain page. Did you review that page with your attorney? Did you understand it?
Yes, ma'am.
According to the plea bargain agreement, punishment is to be assessed at 6 years in the prison, $1,500 fine, probated. State recommends community supervision and no firearm possession. Did you understand that to be the plea bargain agreement?
Yes, ma'am.
Defense, is that the plea bargain agreement?
Yes, it is, Your Honor.
State, is that the plea bargain agreement?
Yes, Your Honor.
Mr. Joe Anthony Thomas, I'm showing you what's entitled waiver of appeal paragraph. Did you review that paragraph with your attorney? Did you understand it? Did you sign
Yes,
it in
ma'am.
both places?
Yes, ma'am.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, ma'am.
Counsel, are there any such motions?
No motions, Your Honor.
Outside the plea bargain agreement, the state is asking that your community supervision be for a term of 6 years. There'll be a TAP evaluation, 120 hours of community service, restitution, and gang evaluation. Did you understand those are recommendations from the state and the court does not have to follow those recommendations?
Yes, ma'am.
Then to the offenses charged in the indictment, how do you plead? Guilty, not guilty, or no contest?
Guilty, ma'am.
State any evidence.
State offers State Exhibit 1 its attachments.
Any objections?
No objections, Your Honor.
Mr. Thomas, I'm showing you what's entitled waiving consent to stipulation of testimony and stipulations. Did you review that document with your attorney? Did you understand it? Did you electronically sign it in all the appropriate places?
Yes, ma'am.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state will call and the right to remain silent?
Yes, ma'am.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there will be no live testimony? Did you understand?
Yes, ma'am.
The court will accept into evidence states exhibits 1 and attachments. The court has reviewed the same. The court finds there is sufficient evidence to find you guilty. The court will find you guilty. Are we proceeding with sentencing?
Yes, Your Honor.
Anything you wish to say on behalf of your client?
He did get in trouble about 10 years ago. Other than that, he's kept his nose clean and worked hard. And that's that you follow the program, the plan, and give him probation.
Mr. Thomas, do you have any children?
Yes, ma'am.
What are their ages?
5 years old, ma'am.
Do you see them?
Yes, ma'am. I get my son every day in the morning till 7. Then I go to work from there tonight.
All right. What is this with the gang evaluation? Do you belong to a gang?
Back when I went to prison the first time, I'm 19 years old, man. But like I said, I've been out for a while already. I haven't been doing nothing. I've been keeping my nose straight. I've been just trying to take care of my son, really.
All right. What do you do for work?
I'm a supervisor at Landry Seafood House on the Riverwalk.
All right. Is your kitchen clean at Landry's?
Yes, ma'am.
All right. So if I come there and eat my dishes and silverware and everything will be clean.
Yes, ma'am.
Okay. All right. This is the court is going to do. Sentence you to 6 years in prison, suspended and probated for 6 years, $1,500 fine, probated, no firearm possession, 120 hours community service restitution. 40 of those hours will be waived if you provide proof of the COVID vaccination. Not requiring you to get that, but if you do, 40 of those hours will be waived. Gang evaluation, parenting classes. You complete your parenting classes, the remaining of your community service hours will be waived. Employment, proof of employment within 15 days. No employment as a home health care provider with minors. If you're drug tested today, what are the results going to be?
Marijuana, ma'am.
All right, you need to stop using, you understand?
Yes, ma'am.
I'm going to want him tested for levels. Regular Zoom reporting. Or in person if you can't report by Zoom. Field visits, 1 time per month, regular. Rebecca, is there anything else he needs?
No, ma'am.
Mr. Thomas, is there anything else you need from the court in order to be successful?
No, ma'am. That's pretty much it. I was wondering about the community service. Like I said, I get my son from 6 o'clock in the morning to almost 7.
Mr. Thomas, if you complete your parenting classes, which you have to complete, you won't have to do community service hours.
Okay, ma'am.
All right. I'm going to show you what's entitled Trial Court Certification of Defendant's Rights to Appeal. Did you review that document with your attorney? Did you understand it? And did you sign it?
Yes, ma'am.
Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Do you understand?
Yes, ma'am.
Because this is a felony conviction, and as you now know, if you didn't know before, you're not allowed to possess any weapons or ammunition. Do you understand?
Yes, ma'am.
All right, good luck to you. I'm going to send you a breakout room probation. We'll go over conditions with you. I'm going to send you, let me see. I'm going to send you to breakout room number 2.
Yes, ma'am. Thank you.
You're welcome. Have a great rest of your day.
You too, ma'am.
All right, Neil Kalfas or Mr. Does?
May I be excused, Your Honor?
Yes.
Good afternoon, Your Honor. I've conferred with Michael. It might be better for him and I just to visit briefly before we come back before the court, unless the court wants to. We don't have an agreement yet.
All right. So Ms. Ferguson, can I have a 30-day reset on Darren Does, please?
We are. I did file a motion to dismiss for violation of Mr. Doze's right to a speedy trial. We were previously, we had a hearing before the court. We had filed a motion to set bond or a writ requesting a bond. That was respectfully denied. And we were reset for April the 25th for what I thought was a trial setting. And I'd conferred with Michelle Hayden for the state between our denial of our request for a bond and the April 25th date. She advised me that she wouldn't be ready on the 25th. And then I conferred with her on the 25th. And we were reset today for what I thought was going to be given a trial date. On our last sitting, which was Monday, a few days ago, it appeared that the court was going to set the trial for June the 4th.
We're going to give you a trial now, Mr. Kalfas. The court just finished a bench trial this week and also a jury trial this week. So we just finished a jury trial today. But Ms. Ferguson, can you put a jury trial date for Mr. Kalfas? And if you could send me that in the chat box, please. And if you could make sure that jury trial date is when I am here.
Give me 1 second, Judge.
Thank you. And then everyone, we're going to take up the plea for Pinelli. I know it's very late. The reason why we're going to take that plea up is because Mr. Pinelli is actually in another county and in custody in that county. And then it's been a long day for everyone. We're going to call it a day after that, Brenna, before they test the fire alarm system. All right, so on Fabian Pinelli, does anyone have the discovery? If that's been signed, and prosecutors, if you have that, if you can just email that to me, please.
Okay, Judge, done.
All right, thank you. Lupe, I'm sending you both of those discovery acknowledgements. Could you please print those out? And Mr. Kalfas, as soon as I get August 16th, Mr. Kalfas.
August the 16th is the quickest trial that I can get.
Yes, we have capital murder scheduled before that. And I will make sure that you are number one on the list. Thank you, Mr. Kalfas.
May I file a motion for reconsideration or have another hearing on my bond at some point?
Yes, if you would, you can confer with Ms. Ferguson on a date for that.
Okay.
And we'll set it as soon as possible. And as soon as possible will be the second week in May.
Thank you, Judge.
You're welcome. All right, the court is calling 2021 CR 9976 and 2021 CR 9803, State of Texas versus Fabian Pinelli. Can I have the parties announced for the record for the state?
Marcus Sanders.
For the defense?
Nathan Slemane.
Defense, in each of these cause numbers, I'm showing you what's entitled a discovery acknowledgement. Have you received all the discovery in each of these cause numbers, and did you review it with your client?
Yes, Your Honor, to both questions.
Mr. Pinelli, in each of the cause numbers, I'm showing you what's entitled defendant's consent to appear by video. Did you review those documents with your attorney? Did you understand them? Did you sign them?
Yes, ma'am.
In each of the cause numbers, the court will find that defendant has knowingly and voluntarily consented to appear by video, and the court will find that the state is in compliance with discovery. Mr. Pinelli, in each of the cause numbers, I'm showing you what's entitled true bill of indictment. Did you review those documents with your attorney? Did you understand them?
Yes, ma'am.
State, are you proceeding on the indictment as presented?
No, Judge. In both cases, we are proceeding on paragraph A only, but we are proceeding on the enhancement paragraphs.
All right, everyone, just give me a moment. All right, any objections from this defense?
No, Your Honor, no objections.
Mr. Pennell, in each of these cause numbers, I'm showing you what's entitled court admonishments and defendants waivers and affidavit of admonitions. Did you review those documents with your attorney? Did you understand them? Did you electronically sign them in all the appropriate places?
Yes, ma'am.
Did you understand in each of the cause numbers, you're charged with burglary of a building with intent to commit theft or a felony? Those are state jail felonies. The range of punishment is anywhere from 180 days up to 2 years in the state jail facility and up to a $10,000 fine. Did you understand?
Yes, ma'am.
Did you understand because the state is proceeding on the habitual offender enhancement allegation, the range of punishment for those offenses, if those repeat offender enhancement allegations are proven to be true, the range of punishment then would be 2 to 20 years in prison and up to a $10,000 fine. Did you understand?
Yes, ma'am.
You understand if you have a plea bargain agreement with the state, the court does not have to follow your plea bargain agreement. If for any reason the court does not follow your plea bargain agreement and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes, ma'am.
Did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state will call and the right to remain silent?
Yes, ma'am.
Did you understand by entering this plea bargain agreement, you were giving up those rights?
Yes, ma'am.
Did you intend to give up those rights and enter into plea bargain agreements in each of these cause numbers?
Yes, ma'am.
Mr. Slimane is entering through another location. All right, to the state, before we go further, and cause number 21 CR 9976.
Hold on, Judge. We have too many things in one room.
Okay. I think I may be missing it, but I don't see the proof of the enhancements.
Yes, Judge, I'm sorry. I forgot to attach them.
No problem. All right, while he's doing that, Mr. Pinelli, did you understand by entering the plea bargain agreement in these cause numbers, you were giving up those rights?
Yes, ma'am.
And did you intend to give up those rights and enter into plea bargain agreements in each one of these cause numbers?
Yes, ma'am.
Counsel, has your client been able to provide you with any defenses to this offense?
Yes, Your Honor, he has.
Do you believe he has a rational as well as a factual understanding of the charges against him?
Yes, Your Honor.
Do you believe he's currently competent, was legally sane at the time of the offense?
Yes, Your Honor.
Mr. Pinelli, in each of these cause numbers, has anyone threatened you, coerced you, or placed you in fear to get you to enter the plea?
No, ma'am.
Has anyone promised you anything other than the plea bargain agreement?
No, ma'am.
Are you satisfied with the way you've been represented?
Yes.
Are you a U.S. citizen?
Yes.
In each of the cause numbers, I'm showing you the plea bargain agreement. Did you review those pages with your attorney? Did you understand them?
Yes, ma'am.
According to the plea bargain agreement, in each of the cause numbers, you're pleading on count 1, paragraph A. Punishment is to be assessed at 5 years in the prison. There are no applications. They're each to run concurrent with each other. The state is taking into consideration the following cause numbers. Brenna, are you ready? CM 97932, 97430, 96474, 96473, 92123, 98124, County Court cause number 651476, grand jury number 759901, 761698, 761710, 759904, 770423, 772020, 2021 CR 9801A as in Apple, 2021 CR 9802, and 2021 CR 9804. Did you understand that to be the plea bargain agreement, Mr. Pinelli?
Yes.
Defense, is that the plea bargain agreement?
That's our agreement, Your Honor.
State, is that the plea bargain agreement?
Yes, Judge.
And each of the cause numbers, I'm showing you what's entitled waiver of appeal paragraph. Did you review that paragraph with your attorney? Did you understand it? Did you electronically sign it in both places?
Yes, Your Honor.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, ma'am.
Counsel, have there been any such motions?
No, Your Honor.
Then in each of the cause numbers, the court will find that defendant has knowingly and voluntarily waived his right to jury trial. Mr. Pinelli, in each of the cause numbers, how do you plead? Guilty, not guilty, or no contest?
No contest.
State, do you have any evidence to support the defendant's plea?
Yes, Judge, the state offers State's Exhibit 1 and its attachments. Additionally, I am emailing, I guess, an attachment to State's Exhibit 1, which are the prior judgments.
Any objections to the state emailing the prior judgments to the court defense?
No, Your Honor, no objections. And as far as admission, we have no objections for the purposes of this hearing.
Mr. Pinelli,
Yes, ma'am.
and cause number 2021 CR 9803, how do you plead to each of the enhancements? True or not true?
True.
And in cause number 2021 CR 9976, how do you plead to the enhancements? True or not true?
True.
State you're offering into evidence State's Exhibits 1 and attachments.
Yes, Your Honor.
Any objections from the defense?
No, Your Honor, no objections.
All right. To the clerk, I've sent you documents to print out, please. Ms. Ranelli, I'm showing you what's entitled Waiver and Consent to Stipulation of Testimony and Stipulations. Did you review those documents with your attorney? Did you understand them? Did you electronically sign them in all the appropriate places?
Yes, ma'am.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state will call and the right to remain silent?
Yes, ma'am.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there'll be no live testimony? Did you understand?
Yes, ma'am.
In each of the cause numbers, the court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence State's Exhibits 1 and attachments, and the court will review the same. All right, after reviewing State's Exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty. The court will find you guilty under each cause number. The court will find the enhancement and allegations true based upon your plea of true and based upon State's Exhibits 1 and attachments. Are you proceeding with sentencing?
Yes, Your Honor.
And each of the cause numbers, the court will sentence you to 5 years in the prison, give you credit for any time served. Each cause number will run concurrent. Thank you. Just one moment, please. All right, I'm sorry about that. In 2021 CR 9976, and in each of the cause numbers, also in 2021 CR 9808, the cases will run concurrent. The court will sentence you to 5 years in the prison, give you credit for any time served. And as previously stated, several cause numbers are being taken into consideration. And those are CM 97932, 97430, 96474, 96473, 92123, 98124. County Court cause numbers 651476. Grand jury numbers 7599901, 7611698, 7611710, 7599904, 770423, 772020. Cause numbers 2021 CR 9801A, 2021 CR 9802, and 2021 CR 9804. Is there anything else from sentencing from each party?
Oh, Your Honor.
From the defense, Your Honor, I would only also ask, as Mr. Pinelli is currently in custody in Atascosa County, he has been in custody continuously since March 13th. We would just ask that the court grant him credit for the time that he's been in custody in Atascosa.
All right, the court will give you any credit for any time that you've been in custody in Atascosa County. Mr. Slimane, you'll need to talk to the clerk about that to make sure that the dates are correct.
Yes, Your Honor.
Mr. Pinelli, in each of the cause numbers, did you receive documents entitled Trial Court Certification of Defendant's Rights to Appeal? Did you review those documents with your attorney? Did you understand them and did you sign them?
Yes, ma'am.
All right, because this is a plea bargaining agreement in each of the cause numbers, and because I followed your plea bargain in each of the cause numbers, you do not have the court's permission to appeal. Do you understand?
Yes, ma'am.
And just one moment. And in each of the cause numbers, Mr. Pinelli, because these are felony convictions, you're not allowed to own or possess any weapons or ammunition. Do you understand?
Yes, ma'am.
If you have a question over what the weapon or the definition of a weapon or ammunition, you'll need to speak to an attorney. Do you understand?
Yes, ma'am.
All right, Mr. Pinelli, good luck to you. My only advice to you is stop stealing. Don't take
Yes,
what doesn't
ma'am.
belong to you. You understand?
Yes, ma'am.
All right, good luck to you. Thank you, Mr. Slimane.
Thank you, Your Honor. Thank you. For the record, I'd like to thank Corporal Delgado at the Atascosa County Jail, has been very accommodating and patient to help us get this done today. So
All right, thank you.
Thank you.
All right, bye-bye.
All right.
All right, Mr. Benary on Daniel Vasquez. We're gonna have to recall this back for another
Yeah,
day.
Judge, I called his phone and it's going straight to voicemail. I mean, I'm assuming it died on him, but I don't know. I cannot get a hold of him.
All right, we'll recall it for May 9th.
Okay, Judge, thank you.
Thank you for your patience.
Thank you, Your Honor. Have a good day.
You're welcome. And Ms. Ferguson on Angel Star, we're gonna recall that for May 9th as well. All right, and we're gonna stop the live stream. It's been a long Thursday, everyone. And I do still have some patience in my pocket if anybody needs any.
I think I'm gonna go drink some patience, Judge.